Good evening to one and all who are present here. I am Vishnu Priya, final year student from Havanur College of Law. I feel privileged to welcome you all to this LG Havanur Endowment special online lecture. This is organized as a part of our week-long webinar series. We are on our third day today. Our college has always been at the upfront of promoting academic learning and intellectual exchange. And today's session continues that proud tradition. Today we are here to discuss a very important topic, recognition under international law. Before we begin, I extend my warm welcome to our respected management, our beloved person, resource person Dr. Shilpa ma'am, our principal Lalita ma'am, faculty members, non-teaching staffs, back-end support team, and all the participants who have joined us today this evening. Thank you for being a part of this academic gathering. And it is my great honor to welcome our distinguished resource person, Dr. Shilpa ma'am. Dr. Shilpa has been awarded a doctorate by Alliance University in May 2025 for a research title, A Study of Women's Access to Justice through Legal Aid Services in Bengaluru District. With over 15 years of experience in teaching, research, and academic leadership, she has served in several reputed institutions, including as assistant professor at RV Institute of Legal Studies and as a vice president at SJR College of Law. Currently, she is the principal of Devanga Sangha College of Law, Bengaluru, where she continues to inspire a lot of students through her legal awareness programs and community oriented programs. Her areas of expertise include international law, human rights, business and trade laws, and sociological research. Dr. Shilpa has published numerous research papers, authored books, and presented at national and international conferences. Her remarkable contributions have been recognized through awards such as National Humanity Award in 2022 and the Certificate of Achievement for Legal Services Coordination in 2024. She also holds a patent in 2024 for a research on AI and workplace well-being. Her work truly reflects her dedication to empowering women, promoting access to justice, and shaping the next generation of legal professionals. We are deeply honored to have you with us today, ma'am. With great respect, I now invite Dr. Shilpa ma'am to address the gathering and deliver her lecture on recognition under international law. Ma'am, the floor
Right.
is yours.
Yes. Thank you, Vishnu Priya, for giving such a wonderful introduction. Yes. Good evening, everyone. Um, Today, I have taken the topic relating to recognition. Everyone know that recognition. 1 minute, please. Yeah. Everyone know that the recognition is very important for us. Without recognition, we cannot make anything. Even to introduce myself, the Vishnu Priya has given what my recognition is, like that, right? So, and based on that, we have to know under international how the state could be recognized. We know that before we going to that, please share the screen, ma'am. That PPT.
We'll do it, ma'am.
Yeah.
Doing it, ma'am.
Yeah, in the introduction, we can state that a new state, it is born out from an existing state or an old state, which disappeared and comes with a new name, or splitting of an existing state into a two states. If a new state enjoys certain rights, privileges, and obligation, then it must get a recognition as a state, which is very essential. However, there are some minimum criteria has to be undergone to recognize the state under international. So, with this, we can say that some of the criterias. When come to the criterias, there is a condition or the essential elements. Ma'am, go to the first slide. The essential elements they have focused. What are those essential elements? Can anyone explain that? What is the essentials of the statehood? Can anyone, please? Please, Vasant Kumar. Hello. Can anybody explain what is the essentials of statehood? To become a state, what are minimum requirements state can get it? Take it example of Karnataka itself. So how the Karnataka has become a state? Anybody?
Ma'am, a state should have a proper territory and it
Yes.
should have a proper governance over the
Yes.
territory. Then it can
Yes.
become a state.
Yes. So there is four essential conditions to become a state under any countries, right? So it has a proper permanent population, definite territory, and government and sovereignty, right? So along with that, there is one another essential conditions under the international law, that is the entity should have the capacity to enter into a relations with other state. Okay, these are all the essential. Then what is recognition? What is recognition? So simply we can say that recognition is the formal acknowledgement by existing states, right? Can you accept it? It is a formal acknowledgement.
Formal acknowledgement of.
Existing states by the political
Okay.
entity. Yeah, can you accept it? That it is
Yes, madam. Yes.
necessary for the formal acknowledgement.
Yes, it becomes a necessary part.
It becomes a necessary part. Yes, right.
Yes.
So recognition is the formal acknowledgement by existing state that a political entity fulfills the conditions of statehood under international law. What are those conditions? Just I focused on those conditions, that is there must be a statehood, that is permanent control, the permanent territory has to be there. There must be a government and sovereignty, that it is politically organized, and definite territory sovereignty over newly acquired state, and independent community, and along with state have the relations, that is enter into a contract with the other states, that is call it as a recognition. Okay, so with going with the definition, the Kelson states that a community has to be recognized as an international person must fulfill the following conditions, that is politically organized, definite territory towards it has to be definite control over the permanence, and constitute with the independent in nature, then we call it as the state can acquire a recognition. The author Oppenheim has to be stated that the recognizing state as a member of international community, and the existing states declare that their opinion of the new state fulfills the conditions of statehood as required by international law. Without that, these essential conditions, the recognition will cannot be happen. Okay, so there must be, to recognize the states, there must be four essential conditions has to be there, and it has to be accepted by the acknowledged by the existing state, those existing state under the UN, those who are taken under the UN membership. Okay, so can anyone tell that how many states are there in the United Nations right now? How many states are there in United Nations?
50, madam.
50. Yes, next, anybody?
193, ma'am.
90.
193, ma'am.
Yes, 193 states. Okay, so 193 states till now recognized under the United Nations. Go to the next slide, ma'am. Yeah. The, as I mentioned, theories of recognition, ma'am. The third slide. Yes, the first we go for the theories of recognition. Yes, so till 193 states are recognized under the United Nations. Okay, how those nations are recognized? Before we move on to the recognition concept under the United Nations, first we look after the theories of recognition and some of the doctrines. According to the theories, there is very two important theory, that is constitutive theory, that is recognition creates by the state, and declaratory theory, that is recognition only acknowledges and existing fact. So what is constitutive theory? According to constitutive theory, it clothes a state with a statehood. The recognition confers the international personality on a state. This theory expounded by the Oppenheim, Holland, Ancelotti, etc. According to them, when a state has to be recognized by the established states acquires rights and obligations under international law. It is only through recognition that a state become a member of the family of the nation and also acquire the international personality. So when the United Nations has to be started, already the 51 members already there, and they are recognized by the declaratory, and they themselves as well, because they are the members of the United Nations. There is not such a thing that they have to be recognized by the other state. But after 51, till now, that is 193 state, you can remove by the 51 state, and remaining states are recognized by the format of these theories and the doctrine format. Okay, so that's why, according to this theory, that is constitutive theory, has to be stated that the participation of the international community is very much essential to the every state when they attain the statehood. Then what is the statehood? What I have given the earlier explanation, that is statehood is nothing but the essential conditions of the state. That is, the state must be politically organized, it have the control over definite territory, and it is permanent and independent, and it has to be it has the qualification of enter into a capacity of enter into a international organization. Okay, then only the state can be recognized. But some of the authors has to be criticized this constitutive theory, because by mere starting up or mere existence of the statehood, it is not an essential to give an recognition to the state. ಕನ್ನಡದಲ್ಲೂ ಬೇಕಾ? Okay, please. Recognition is in political consideration and retroactive. ಸೊ ಇದುವರೆಗೂ ನಾನು ಏನ್ ಹೇಳ್ದೆ, ಮಾನ್ಯತೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಇವಾಗ ನನ್ನನ್ನ ಮೊದಲು ಇಲ್ಲಿ ಹೇಳುವಾಗ ನಾನು ಯಾರು ಅಂತ ನನ್ನನ್ನ ಪರಿಚಯ ಮಾಡ್ಕೊಂಡ್ರು, ನೀವು ಅಷ್ಟೇ ಎಲ್ರು ಕೂಡ ಲಾ ಸ್ಟೂಡೆಂಟ್ಸ್ ಅಂತ ಹೇಳ್ಬೋದು. ನಿಮ್ಮನ್ನ ನೀವು ಹೇಗೆ ರೆಕಗ್ನೈಸ್ ಮಾಡ್ಕೊಳ್ತೀರಾ ಅಂತ ಹೇಳಿದ್ರೆ, ನೀವ್ ಯಾರು ಅನ್ನೋದನ್ನ ಹೇಳ್ತೀರಾ. ಹಾಗೆ ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ಈ ಒಂದು ರಾಷ್ಟ್ರಗಳು ಹೇಗೆ ಮಾನ್ಯತೆಯನ್ನ ಗಳಿಸ್ಕೊಳ್ತವೆ ಅಥವಾ ಮನ್ನಣೆಯನ್ನ ಗಳಿಸ್ಕೊಳ್ತವೆ ಅಂತ. ವಿಶ್ವಸಂಸ್ಥೆಯಲ್ಲಿ ಮೊದಲು ವಿಶ್ವಸಂಸ್ಥೆ ಸ್ಥಾಪನೆ ಆದಾಗ 51 ರಾಷ್ಟ್ರಗಳು ಆಲ್ರೆಡಿ ಮನ್ನಣೆಯಲ್ಲಿದ್ವು. ಅವೆಲ್ಲವೂ ಸೇರಿನ ವಿಶ್ವಸಂಸ್ಥೆಯನ್ನ ಸ್ಥಾಪನೆ ಮಾಡಿದ್ವು. ಆದ್ರೆ ಈಗ ಇರುವಂತಹ 193 ರಾಷ್ಟ್ರಗಳು, ಹಾಗಾದ್ರೆ ಉಳಿದಂತ 51ನ್ನ ಬಿಟ್ಟು ಉಳಿದಂತ ರಾಷ್ಟ್ರಗಳು ಹೇಗೆ ಮನ್ನಣೆಯನ್ನ ಗಳಿಸ್ಕೊಂಡ್ವು ಅಂತ ಹೇಳಿದ್ರೆ, ಅದಕ್ಕೆ ತನ್ನದೇ ಆದಂತಹ ಕೆಲವೊಂದು ನಿಯಮಗಳನ್ನ ವಿಶ್ವಸಂಸ್ಥೆ ರಚನೆ ಮಾಡಿದೆ. ಆ ನಿಯಮಗಳೇ ಇರುವಂತದ್ದು ಘೋಷಣಾತ್ಮಕ ಮತ್ತೆ ಈ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟಿವ್ ಥಿಯರಿಯಲ್ಲಿ ಹೇಳಿರುವಂತದ್ದು. ಹಾಗಾದ್ರೆ ಮನ್ನಣೆ ಅಂದ್ರೆ ಏನು? ಯಾವ ರಾಷ್ಟ್ರ ತನ್ನದೇ ಆದಂತಹ ಒಂದು ರಾಜಕೀಯ ಪ್ರಭುತ್ವವನ್ನ ಹೊಂದಿರುತ್ತೆ, ಮತ್ತೆ ಭೂಪ್ರದೇಶವನ್ನ ಹೊಂದಿರುತ್ತೆ, ಅದು ಸ್ಥಿರವಾದ ಭೂಪ್ರದೇಶವಾಗಿರ್ಬೇಕು ಮತ್ತು ಸ್ವತಂತ್ರವಾಗಿರ್ಬೇಕು, ಸಾರ್ವಭೌಮತೆಯಿಂದ ಮತ್ತೊಂದು ರಾಷ್ಟ್ರದ ಜೊತೆ ತನ್ನನ್ನು ತಾನು ಯಾವುದೇ ರೀತಿಯಲ್ಲಿ ಒಪ್ಪಂದಗಳನ್ನು ಮಾಡುವಂತಹ ಅರ್ಹತೆನ ಹೊಂದಿರ್ಬೇಕು. ಇದೊಂದು ನೆನ್ಪಿಟ್ಕೊಳ್ಳಿ. ಇಂಟರ್ನ್ಯಾಷನಲ್ ದಲ್ಲಿ ಎಲ್ಲಾ ಬರೀತಾರೆ ಸ್ಟೇಟ್ಹುಡ್, ಆದ್ರೆ ಕೊನೆಗೆ ಇಂಪಾರ್ಟೆಂಟ್ ಬೇಕಾಗಿರೋದೇ ಬರೆಯೋದಿಲ್ಲ. ದಟ್ ಈಸ್ ದ state has the capacity to enter into a contract or enter into a relations between the other state. That is very important. ಆ ಒಂದು ರಾಷ್ಟ್ರ ಮತ್ತೊಂದು ರಾಷ್ಟ್ರದ ಜೊತೆ ಸಂಬಂಧಗಳನ್ನ ಏರ್ಪಡ್ಲಿಕ್ಕೆ ಅರ್ಹತೆಯನ್ನ ಹೊಂದಿರ್ಬೇಕು, ಆಗ ಮಾತ್ರ ಅದಕ್ಕೆ ಮನ್ನಣೆಯನ್ನ ಕೊಡ್ತಾರೆ ಅಂತ. ಅದನ್ನ ಇಲ್ಲಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟಿವ್ ಅಂದ್ರೆ ತತ್ಸಂಬಂಧಿತವಾದ ಒಂದು ಸಿದ್ಧಾಂತದಲ್ಲಿ ಹೇಳಿದ್ದೇನಂದ್ರೆ, ಯಾವುದೇ ರಾಷ್ಟ್ರ, ಸೊ ಎನಿ ಸ್ಟೇಟ್, ಯಾವುದೇ ರಾಷ್ಟ್ರವನ್ನ ನಾವು ರೆಕಗ್ನೈಸ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಆ ರಾಷ್ಟ್ರ ಸ್ಟೇಟ್ ಹುಡ್ನ ಇರ್ಬೇಕು, ಅಂದ್ರೆ ರಾಜ್ಯಕ್ಕೆ ಬೇಕಿರುವಂತಹ ಎಸೆನ್ಷಿಯಲ್ ಕಂಡೀಷನ್ ಇರ್ಬೇಕು, ಮತ್ತೆ ಆ ಒಂದು ಆಧಾರದ ಮೇಲೆ ರೆಕಗ್ನೈಸ್ ಮಾಡ್ತಾರೆ ಅಂತ. ಆದ್ರೆ ಇದೊಂದೇ ಸಾಕಾಗಲ್ಲ ಅನ್ನೋದನ್ನ ಎಲ್ರು ಕೂಡ ಕ್ರಿಟಿಸೈಸ್ ಮಾಡಿದ್ರು. ಆ ಕ್ರಿಟಿಸೈಸ್ ಹೇಳಿದ್ದೇನಂದ್ರೆ, ಬರೀ ಮಿಯರ್ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಅಂದ್ರೆ ಎಕ್ಸಿಸ್ಟೆಂಟ್ ಆದ ತಕ್ಷಣ ಒಂದು ರಾಷ್ಟ್ರ ಇದೆ, ಅದು ಸ್ಟೇಟ್ಹುಡ್ ಇದೆ ಅಂದ ತಕ್ಷಣ ಅದಕ್ಕೆ ಮನ್ನಣೆ ಕೊಡಕ್ಕಾಗಲ್ಲ. ಯಾಕಂದ್ರೆ ಅದು ಫುಲ್ಫಿಲ್ ಆಗಿರುತ್ತಾ, ಅದು ಏನಾದ್ರು ರೆಕಗ್ನೈಸ್ ಆಗ್ಬೇಕಂದ್ರೆ ರಾಂಗ್ ವೇ ಅಲ್ಲೂ ಕೂಡ ಕೆಲವೊಂದನ್ನ ತೋರಿಸಿರ್ಬೋದು, ಅದನ್ನೇ ಕೊಡಕ್ ಸಾಧ್ಯ ಇಲ್ಲ. ಹಾಗಾಗಿ ಡಿಕ್ಲರೇಟರಿ ಆಗ್ಬೇಕು, ಇರುವಂತಹ ರಾಷ್ಟ್ರಗಳ ಮನ್ನಣೆನೂ ಸಿಗ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರು. ದಟ್ ಈಸ್ ವಿ ಕಾಲ್ ಇಟ್ ಆಸ್ ಎ ಡಿಕ್ಲರೇಟರಿ ಥಿಯರಿ. ದಟ್ ಈಸ್ ರೆಕಗ್ನಿಷನ್ ಓನ್ಲಿ ಅಕ್ನಾಲೇಜಸ್ ಅಂಡ್ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಫ್ಯಾಕ್ಟ್. ದಟ್ ಈಸ್ the already the states who are there under the United Nations, they have to be acknowledged along with the 5 permanent members, and the other state has to give a vote. So for example, take it example of to introduce any laws under the parliament, we need some certain votes, right? 2/3 majorities of vote. Like that, in general assembly, when the new state has to be acknowledged and give an application, it has to put it in a vote that whether such state can be recognized or not. So the resolution has to be passed by the general assembly after fulfillment of these criteria. Before they will they have to be recognized, when the statehood has to be clearly mentioned by the state, then they will give the formal recognition. That's it. So once they have fulfilled all the criteria, then they go for the legally recognition. So I will discuss with that is de jure and de facto. Okay, so that declaratory theory has to be made that it is a formal acknowledgement. The formal acknowledgement means the statehood authority, a new government exists before the act of recognition. It merely declaration of the existing fact. Particularly, the government possesses the essential requisites of the statehood and acquired by the international law. The granting of recognition of a new state is not constitutive, but it is a declaratory act, because this theory states that recognized by the other state still exists by the treated as a state. The Soviet view suggests that the birth of a state is the act of internal law rather than the international law. So, why this declaratory theory has to be mainly focusing on these issues? Because for the purpose of recognition of the state, there is a very important convention, that is Montevideo Convention. So according to Montevideo Convention of 1933, it has given 1933, it has given the essentials of these recognitions of the state. So what are all the 5 essential conditions which I have given now? Those essential conditions has to be given under the convention, that is Montevideo Convention. That is very important. With respect to that, there is a case law, that is Crawford versus the Queen, that is Canada in 1961. In this case, they have to be reaffirmed the Montevideo Convention requirement for the recognition of the state. What are those criteria which are given under the Montevideo Convention? That is population, territory, government, the capacity to enter into a international relation. It is very important. So by giving an useful explaining when an entity qualifies as of a state before a recognition, along with these statehood, and the recognitions of the other state is very important. It has to be explained by the court itself. So ಯಾವಾಗ ಈ ಮಾಂಟೆವಿಡಿಯೋ ಕನ್ವೆನ್ಷನ್ ಏನಿದೆಯಲ್ಲ, ಇದು ಇಂಪಾರ್ಟೆಂಟ್. ಮೊನ್ನೆ ವಿಷಯದಲ್ಲಿ 1933 ಏನು ಬಂತು, ಇದರಲ್ಲಿ ಹೇಳಿದ್ರು ಅಂದ್ರೆ ವಿಶ್ವಸಂಸ್ಥೆ ಬರೋ ಮುಂಚೆ ನಮ್ದು ಲೀಗ್ ಆಫ್ ನೇಷನ್ ಏನಿತ್ತು, ಆ ಟೈಮಲ್ಲೇ ಈ ಎಲ್ಲಾ ಕನ್ವೆನ್ಷನ್ಸ್ ಗಳನ್ನ ಮಾಡಿದ್ರು. ಅದು ಹೋಯ್ತು ಅನ್ನೋ ಕಾರಣಕ್ಕೆ, ಅಂದ್ರೆ ಲೀಗ್ ಆಫ್ ನೇಷನ್ಸ್ ಆಫ್ಟರ್ ಫಸ್ಟ್ ವರ್ಲ್ಡ್ ವಾರ್ ಮೇಲೆ ಅದು ಫಾಲನ್ ಆಯ್ತು ಅಂದ್ರೂ ಕೂಡ, ರೆಕಗ್ನಿಷನ್ ಮಟ್ಟದಲ್ಲಿ ಮತ್ತೆ ರಚನೆ ಆದಂತಹ ವಿಶ್ವಸಂಸ್ಥೆ ಕೂಡ ಅದೇ ನೀತಿಗಳನ್ನ ಅನುಸರಿಸ್ಕೊಳ್ತಾ ಬಂತು. ಅದೇ ಸ್ವಲ್ಪ ಮಾರ್ಪಾಡುಗಳನ್ನ ಮಾಡ್ತಾ ಬಂತು. ಸೊ ಆ ಒಂದು ಕನ್ವೆನ್ಷನ್ ನ ಆಧಾರದ ಮೇಲೆ ಒಂದು 61ರಲ್ಲಿ ಕ್ರಫೋರ್ಡ್ ವರ್ಸಸ್ ಕ್ವೀನ್ ಆ ಒಂದು ಪ್ರಕರಣದಲ್ಲಿ ಅದನ್ನ ರೆಕಗ್ನೈಸ್ ಮಾಡ್ಬೇಕೋ ಬೇಡವೋ ಕ್ವೀನ್ ಗವರ್ನಮೆಂಟ್ ಅಂತ ಹೇಳಿದಾಗ, ಆ ರಾಷ್ಟ್ರವನ್ನ ಸ್ಟೇಟ್ಹುಡ್ ಇದ್ರೆ ರೆಕಗ್ನಿಷನ್ ಮಾಡಿ ಅದಕ್ಕೆ ಫುಲ್ಫಿಲ್ಮೆಂಟ್ ಆಗ್ಲಿಕ್ಕೆ ಒಂದಷ್ಟು ಸರ್ಟನ್ ಟೈಮ್ ಅನ್ನ ಕೊಡಿ. ಡಿ ಜೂರೆಗೆ ಅಂದ್ರೆ ಲೀಗಲಿ ಬರ್ಬೇಕಂದ್ರೆ, ಜೊತೆಗೆ ಪೊಲಿಟಿಕಲಿ ಅದು ರೆಕಗ್ನೈಸ್ಡ್ ಆಗ್ಲೇಬೇಕು ಅನ್ನೋದನ್ನ ಆ ಒಂದು ಪ್ರಕರಣದಲ್ಲಿ ಅವರು ಹೇಳಿದ್ರು. ಸೊ ಇನ್ನೊಂದು ಅದೇ ರೀತಿಯಾದಂತಹ ಒಂದು ಪ್ರಕರಣವನ್ನ ಮೇನ್ ಆಗಿ ಅವ್ರು ತಗೊಂಡಿದ್ದು ಯಾವ್ದಂದ್ರೆ ದ ಅರ್ನತ್ ಹಾಜು ಮೆಹಂದಿ ಕೇಸ್ ಅಂತ, UK in 1939 ಅಲ್ಲಿ, ಅಂದ್ರೆ ಲೀಗ್ ಆಫ್ ನೇಷನ್ ಇರುವ ಟೈಮ್ ಅಲ್ಲಿ. The UK court held that recognition by the UK government, it has to be determines whether a foreign authority has to be considered as a state before the courts. They are taking with the support of the constitutive theory, depends on the statehood of the recognition. They said that yes, by mere recognizing the state, when the state has to be fulfilled the statehood, that is essential conditions of the, that is politically recognized, it has definite territory, permanent, and capacity to enter into a international relation. That is very much important. Based on that first step, you have to recognize the state, and if you need anything further step or further conditions has to be fulfilled by those state, then you can given a time. If state is not in certain time state is not fulfilled those conditions, then you can cancel it. But state remain as it is, but it is not recognized under the United Nations, under the countries of United Nations. But it is recognized, even though some of the states are there in the world, but some states, only the 193 states are recognized, but other states remain as it is. Okay, take it as Tinanko arbitration case also. It is a declaratory, held that recognition is a declaratory. The Tinanko regime was valid even if it not recognized by the all state. This is a very good example, because even the Tinoco arbitration, according to this case, the Tinoco country is not recognized by the all the state, but it remain as it is, because the states has to be stated that it has fulfilled all the statehood, and it's remain a state, but it is not coming into the purview of the under the membership of the United Nations. Okay, in island case also, recognition cannot be given to the entities not fulfilling the statehood requirements. So see here, the statehood is very important, because in the Montevideo Convention they are highlighted mainly focusing on, once the state has to be recognized under the international community, it must fulfill the statehood. If it is not fulfill the statehood, any one, then those islands cannot be given to the, because definite territory is not there in the Aland Islands, and the islands is not recognized under the state. Okay, coming to the, yes, this example I will explain with one by one while giving the thing. So in Bangladesh, 1971, it has recognized after the independence, because before that they have given only constituted based on de facto recognition. Even in the Kosovo also, it is recognized in 2008 by many, but not all the states. Okay, so there is like the 2/3 majority what is there. So based on that, even in the Palestine recognized 130 plus state, but not in the UN members. Okay, other members are recognized, but UN members, those who are in the 193 states, they are not recognized. In the Taiwan also, limited recognition due to one China policy, because China has made some of the policies, that is, even though they are permanent membership, China always in the when the recognition taken place, China is always in the behind, so it will not give every state as a recognition under the United Nations. Okay, in Crimea, the annexation not recognized internationally, because it has not fulfilled the criteria which is essential for the things. So that's why this state is also not recognized. Coming to the kinds of recognition, because in the exam point of view, examinally ನಿಮಗೆ ಹೇಳಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ಈ ಕೆಲವೊಂದನ್ನ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಅಂದ್ರೆ ಡಿ ಜೂರೆ ಮತ್ತೆ ಡಿ ಫ್ಯಾಕ್ಟೋ, ಅಂದ್ರೆ ಕಾನೂನಾತ್ಮಕವಾಗಿ ಮತ್ತು ವಾಸ್ತವಿಕವಾಗಿ ಹಾಗೆ ಷರತ್ತುಬದ್ಧವಾಗಿ ಹೇಗೆ ಮನ್ನಣೆಯನ್ನ ಕೊಡ್ತಾರೆ, ಇಂಪಾರ್ಟೆನ್ಸ್ ಏನು, ಜೊತೆಗೆ ಅದ್ರ ನಡುವೆ ಇರ್ತಕ್ಕಂಥ ಡಿಫ್ರೆನ್ಸ್ ಏನು ಅನ್ನೋದನ್ನ ಕೇಳ್ತಾರೆ. ಸೊ ಇದುವರೆಗೂ ನಾನು ಹೇಳಿದ್ರು ಘೋಷಣಾತ್ಮಕ ಸಿದ್ಧಾಂತ ಅಂತ ಹೇಳಿದ್ರೆ ಸ್ಟೇಟ್ಹುಡ್ ಅನ್ನ, ಅಂದ್ರೆ ಒಂದು ರಾಷ್ಟ್ರಕ್ಕೆ ಬೇಕಾಗಿರುವಂತಹ ಎಲ್ಲ ಅವಶ್ಯಕ ಅಂಶಗಳನ್ನು ಪಡೆದ ಮೇಲೆ ಸಂಬಂಧಿಸಿದಂತಹ ರಾಷ್ಟ್ರಗಳು, ಯಾವ ಸದಸ್ಯತ್ವ ರಾಷ್ಟ್ರಗಳು ಕೂಡ ಒಪ್ಕೊಂಡು ಮನ್ನಣೆಯನ್ನ ಕೊಡ್ತವೆ. ಕೆಲವೊಂದು ರಾಷ್ಟ್ರಗಳು, ಈಗ ಎಕ್ಸಾಂಪಲ್ ತೋರಿಸಿದ್ರು ಅವರು, ಕೆಲವೊಂದು ತೈವಾನ್ ಇರ್ಬೋದು, ಅವೆಲ್ಲ ಕೆಲವೊಂದು ಅವುಗಳ ಪ್ರಕಾರ ಕೆಲವು ರಾಷ್ಟ್ರಗಳು ಮಾಂಟೆವಿಡಿಯೋ ಕನ್ವೆನ್ಷನ್ ಸ್ಟೇಟ್ಹುಡ್ ಆಧಾರದ ಮೇಲೆ ಮತ್ತು ಷರತ್ತುಗಳನ್ನ ಕೊಟ್ಟ ಮೇಲೆ, ಆ ಷರತ್ತುಗಳನ್ನ ಪೂರೈಸಿದ ಮೇಲೆ ಅವು ಕಾನೂನಾತ್ಮಕವಾಗಿ ಘೋಷಣಾತ್ಮಕವಾಗಿ ಮನ್ನಣೆಯನ್ನ ಪಡ್ಕೊಂಡು. ಆದ್ರೆ ಕೆಲವು ರಾಷ್ಟ್ರಗಳು ಈವನ್ ಕಂಡೀಷನ್ಸ್ ಹಾಕಿರೋ ಫುಲ್ಫಿಲ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದಾಗ ಆ ರೆಕಗ್ನಿಷನ್ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು, ಕೊಡ್ಲಿಲ್ಲ, ಮನ್ನಣೆಯನ್ನ ಕೊಡ್ಲಿಲ್ಲ. ಆದ್ರೆ ವಾಸ್ತವಿಕವಾಗಿ ಅವು ರಾಷ್ಟ್ರ ಅಂತ ಅನಿಸ್ಕೊಳ್ತವೆ. ಆದ್ರೆ ಈ ಮೆಂಬರ್ ಅಂದ್ರೆ ಈ ಕಮ್ಯುನಿಟಿ ಒಳಗೆ ಬರಲ್ಲ, ಅಂತಾರಾಷ್ಟ್ರೀಯ ಕಮ್ಯುನಿಟಿ ಆದ ಯುನೈಟೆಡ್ ನೇಷನ್ಸ್ ಒಳಗೆ ಅವುಗಳು ಬರಲ್ಲ. ಇನ್ನೊಂದು ಥಿಯರಿ ಇದೆ, ಫೆಕ್ಯುಲೇಟಿವ್ ಥಿಯರಿ ಅಂತ. ಇಟ್ ಇಸ್ ನಾಟ್ ದಟ್ ಮಚ್, ಬಟ್ ಎ ಸ್ಟೇಟ್ ಟು ಬಿ ರೆಕಗ್ನೈಸ್ ಶುಡ್ ಪೊಸೆಸ್ ದಿ essential of the statehood. ಇದ್ರಲ್ಲೂ ಕೂಡ statehood ಅಂತಾನೆ ಹೇಳ್ತಾರೆ. So with respect to these things, along with the theory, there is three important doctrines has to be established. That is Estrada doctrine. Estrada, who was foreign minister in Mexico in 1930, he laid on the policy according to the duty of a state continue the diplomatic relations with state without regard to the revolutionary changes. So here Estrada person, the foreign minister, he has to be made that issuing the diplomatic relations between the other nation, it is essential that the state has to be fulfill the statehood. Based on that, recognition has to be taken place by the thing, and based on this doctrine, the UK has followed to recognize some of the states. Okay, so till 1980, this doctrine has to be accepted by the UK and US courts. Next, Tobar doctrine. Tobar is also propounded by the Tobar of Ecuador. According to this doctrine, recognition should not be given to the any government which has come in power in the revolutionary means. This was incorporated by the 5 Central American Republican in their territory of 1907 and 1923. According to Tobaro, if any states, if they are coming in the form of revolutionary, what is revolutionary? The peoples of those states has to be made, and they any one of the leader of revolutionary, they come into and they can take it by the things, then those state will not be recognized according to the Tobarro Doctrine. It will be taken into consideration in the US. Okay, while recognizing, the US has to be followed by these things. Next, Stimson Doctrine of non-recognition. According to this doctrine, the non-recognition was promoted by the Manco situation. According, Japan was invaded in this doctrine while giving an recognition in the province of China in 1931 to 32. The recognition of Monaco, the League of Nations sent a fact-finding committee to the Manchukuo, that is committee found overall influence of the Japan's officers in the administration, but did not say that Manchukuo was not an independent state because it is in the control of the Japan. So that's why they Manchukuo, it is not recognized under the thing. That is, next is Halston Doctrine. This doctrine was unofficial but widely used shorthand for the West Germany while recognizing the other state in that. So based on these doctrine also, some of the thing has to be recognized by the international level. So coming to the very main important question, that is types of recognition, that is de jure and de facto recognition. Coming to first, de facto. What do you mean by de facto? State generally employ the de facto recognition while recognition of the new state. De facto recognition, it is a temporary, therefore subject to the revocation by the state granting. It is said that stepping stone towards the permanent recognition. The purpose of granting de facto recognition is to observe the permanency of the new state, whether state has to be capable of fulfilling the obligations under international law. If the new state performs its obligation regularly and efficiently, then permanent recognition may be granted. That permanent recognition, we call it as a de jure. ಡಿ ಫ್ಯಾಕ್ಟೋ ಅಂತ ಹೇಳಿದ್ರೆ ವಾಸ್ತವಿಕ ಸಿದ್ಧಾಂತ. ಇವಾಗ ನಾವೇನು ಡಾಕ್ಟ್ರಿನ್ಸ್ ಗಳನ್ನ ನೋಡಿದ್ರೆ ಎಸ್ಟ್ರಾಡಾ ಅವರೆಲ್ಲ ಏನ್ ಹೇಳಿದ್ದಾರೆ, ಎಸ್ಟ್ರಾಡಾ ಆಗ್ಬೋದು, ಟೂಬರೋ ಆಗ್ಬೋದು, ಅವರವರ ಪ್ರಾಂತ್ಯದಲ್ಲಿ ರಾಷ್ಟ್ರಗಳನ್ನ ಅಥವಾ ರಾಜ್ಯಗಳನ್ನ ಅವರು ವಾಸ್ತವಿಕವಾಗಿ ಆ ರಾಜ್ಯಗಳು ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ರೆಕಗ್ನೈಸ್ಡ್ ಆಗಿರ್ಬೇಕು, ಮತ್ತೆ ಸ್ಟೇಟ್ಹುಡ್ ಇದ್ರೆ ಮಾತ್ರ ರೆಕಗ್ನೈಸ್ ಕೊಡ್ತಿದ್ವಿ. ಜೊತೆಗೆ ಮತ್ತೊಂದು, ಇವಾಗ ಜಪಾನ್ ಇದು ಬಂದಾಗ ಪ್ಯಾಲೆಸ್ಟೈನ್ದು ಸ್ಟಿಮ್ಸನ್ ಡಾಕ್ಟ್ರೈನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರು, ಮೊಂಚುಕೋ ಕಂಟ್ರಿಗೆ ಜಪಾನೀಸ್ ಅವ್ರದ್ದು ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಜಾಸ್ತಿ ಇತ್ತು. ಯಾಕಂದ್ರೆ ಅವರು ಹೆಚ್ಚು ಅಲ್ಲಿ ಆಡಳಿತಾತ್ಮಕವಾಗಿರೋ, ಅಲ್ಲಿ ಯಾವುದೇ ರೀತಿ ಸ್ವತಂತ್ರ ಇರ್ಲಿಲ್ಲ ಆ ಮಂಚುಕೋ ಕಂಟ್ರಿಗೆ. ಹಾಗಾಗಿ ಅದನ್ನ ರೆಕಗ್ನಿಷನ್ ಮಾಡಲ್ಲ ಅಂತ ಲೀಗ್ ಆಫ್ ನೇಷನ್ಸ್ ಹೇಳಿತ್ತು. ಸೊ ಹಾಗಾಗಿ ಕೆಲವೊಂದು ಅರ್ಥದಲ್ಲಿ ಯಾವಾಗ ನಮ್ಗೆ ಕೊಟ್ಟಿರುವಂತಹ, ಅಂದ್ರೆ ಈ ಯುನೈಟೆಡ್ ನೇಷನ್ ಅಲ್ಲಿ ಇರುವಂತಹ ಗೊಂದಲಗಳಿಗೆ ಇದಾಗುತ್ತೆ, ಅವಾಗ ಅವರು ಆ ಡಾಕ್ಟ್ರಿನ್ ಗಳನ್ನ ಈಗಲೂ ಕೂಡ ಫಾಲೋ ಮಾಡ್ತಾರೆ, ನಾವ್ ಯಾವ್ದ್ರ ಮೇಲೆ ಅದನ್ನ ಹೋಗ್ಬೇಕಾಗುತ್ತೆ ಅಂತ. ಸೊ ಹಾಗೆ ಈ ಡಿ ಫ್ಯಾಕ್ಟೋ ಅಂತ ಬಂದಾಗ, ವಾಸ್ತವಿಕವಾದ ಮನ್ನಣೆ ಅಂತ ಬಂದ್ರೆ ಇದು ತಾತ್ಕಾಲಿಕ, ಪೂರ್ಣವಾಗಿ ಕೊಟ್ಟಿರಲ್ಲ, ಅಂದ್ರೆ ಸೀಮಿತ ಅವಧಿಗೆ. ಏನಂದ್ರೆ ಒಂದು ರಾಷ್ಟ್ರ ತಾನು ಸ್ಟೇಟ್ಹುಡ್ ಅನ್ನ, ಅಂದ್ರೆ ಅವಶ್ಯಕ ಅಂಶಗಳನ್ನ ಪೂರೈಸಿದೀನಿ, ನನಗೂ ರಾಜ್ಯ ಆಗ್ಲಿಕ್ಕೆ ಅಥವಾ ರಾಷ್ಟ್ರ ಆಗ್ಲಿಕ್ಕೆ, ಯಾಕಂದ್ರೆ ನಾವು ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ಒಂದೊಂದು ರಾಷ್ಟ್ರವನ್ನ ರಾಜ್ಯ ಅಂತಾನೆ ಹೇಳ್ತೀವಿ, ಅದಕ್ಕೆ ಸ್ಟೇಟ್ ಅಂತ ಯೂಸ್ ಮಾಡ್ತೀವಿ, ಎಲ್ಲೂ ನಾವು ಕಂಟ್ರಿ ಅಂತ ಯೂಸ್ ಮಾಡಲ್ಲ. ಸೊ ನಾನು ಸ್ಟೇಟ್ಹುಡ್ ಇದ್ದೀನಿ, ನನಗೂ ಪೊಲಿಟಿಕಲಿ ಆರ್ಗನೈಸ್ಡ್ ಇದೆ, ಡೆಫಿನೆಟ್ ಭೂಪ್ರದೇಶ ಇದೆ, ನನಗೂ ಕೂಡ ಕೆಪಾಸಿಟಿ ಇದೆ ಮತ್ತೊಂದು ರಾಷ್ಟ್ರ ಜೊತೆ ಒಪ್ಪಂದವನ್ನ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಅಂತ ಎಲ್ಲ ಹೇಳ್ಬಿಟ್ಟು ಅಪ್ಲಿಕೇಶನ್ ನ ಕೊಡುತ್ತೆ. ಆದ್ರೆ ಆ ಅಪ್ಲಿಕೇಶನ್ ತಗೊಂಡ್ಮೇಲೆ ಅವ್ರಿಗೆ ಅನ್ಸುತ್ತೆ ಇನ್ನೂ ಕೆಲವೊಂದು ಅಂಶಗಳು ಈ ಸ್ಟೇಟ್ ಪರ್ಮನೆಂಟ್ ನೇಚರ್ಗೆ ಬರ್ಬೇಕಂದ್ರೆ ಫುಲ್ಫಿಲ್ ಮಾಡ್ಬೇಕು, ಗೌರ್ನಮೆಂಟ್ ಬಗ್ಗೆ ತಿಳಿಸ್ಬೇಕು, ಅವ್ರು ತಿಳಿಸಿರಲ್ಲ. ಯಾಕಂದ್ರೆ ರೆಕಗ್ನಿಷನ್ ಆಗ್ತಿದ್ರೆ ಅಂದ್ರೆ ಗೌರ್ನಮೆಂಟ್ ಕೂಡ ರೆಕಗ್ನೈಸ್ಡ್ ಆಗ್ಬೇಕಲ್ಲಿ. ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಎರಡೂ ಬೇರೆ ತರ ಇರುತ್ತೆ, ಒಂದ್ಸಲ ರೆಕಗ್ನಿಷನ್ ಆಗಿಲ್ಲ, ಗೌರ್ನಮೆಂಟ್ ಬೇರೆ ಇದ್ರೆ ಅಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯಾದ ಇದ್ ಮಾಡಲ್ಲ. ಪದೇ ಪದೇ ಗೌರ್ನಮೆಂಟ್ ಗಳು ಚೇಂಜ್ ಆಗ್ಬೋದು, ಆದ್ರೆ ಆ ರಾಷ್ಟ್ರದ ರೆಕಗ್ನಿಷನ್ ಹಾಗೆ ಒಂದು ಸಲ ಡಿ ಜೂರೆ ಆದ್ರೆ ಅದು ಹಾಗೆ ಇರುತ್ತೆ. ಇವಾಗ ಯಾಕಂದ್ರೆ ನಮ್ಮಲ್ಲೂ ಕೂಡ 5 ವರ್ಷಕ್ಕೊಂದ್ಸಲ ಪೊಲಿಟಿಕಲಿ ದೇ ಚೇಂಜ್, ಕಾಂಗ್ರೆಸ್ ಆರ್ ಬಿಜೆಪಿ, ಬಟ್ ಸ್ಟೇಟ್ ಈಸ್ ಆಲ್ರೆಡಿ ರೆಕಗ್ನೈಸ್ಡ್, ಪರ್ಮನೆಂಟ್ ನೇಚರ್ ಆಗಿ ನಾವು ರೆಕಗ್ನೈಸ್ಡ್ ಆಗಿರೋದ್ರಿಂದ, ಸೊ ಈವನ್ ದ ಗವರ್ನಮೆಂಟ್ ಮೇ ಚೇಂಜ್ ಬಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಅಫೆಕ್ಟ್ ಬೈ ದಿ ರೆಕಗ್ನಿಷನ್. ಓಕೆ, ಸೊ ದಟ್ಸ್ ವೈ ಸಮ್ ರಿಸ್ಟ್ರಿಕ್ಷನ್ಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ದೇರ್ ಅಂಡರ್ ದಿ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಲಾ. ವಾಸ್ತವಿಕವಾಗಿ ಕೊಡುವಾಗ ಆ ಫುಲ್ಫಿಲ್ ಆದ್ರೆ ಡಿ ಜೂರೆಗೆ ಹೋಗ್ತಾರೆ. ದೆನ್ ವಾಟ್ ಇಸ್ ಡಿ ಜೂರೆ ರೆಕಗ್ನಿಷನ್? This recognition granted to a new state when it has fulfilled all its obligation. ಇದೆಲ್ಲ ರಾಷ್ಟ್ರಕ್ಕೂ ಅಲ್ಲ. So already 51 permanent nations which are already there in the United Nations, they are already taken a de jure recognition in initial stage itself. After that, those states came into the purview of the United Nations as a international community membership. They recognized based on the de jure, but after fulfilling of these are all the things. That is, it is set to a permanent recognition and it is irrevocable. ಬಟ್ ಸ್ಟ್ರಿಕ್ಟ್ಲಿ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಹೋದಾಗ ಏನ್ ಆಗ್ಬಹುದು, ಕೋರ್ಟ್ ಇಟ್ ಮೇ ಬಿ ಚೇಂಜಸ್ ಆಗಬಹುದು. ಬಟ್ ಒನ್ಸ್ ದ ಡಿ ಜೂರೆ ರೆಕಗ್ನಿಷನ್ ದ ಸ್ಟೇಟ್ ಕ್ಯಾನಾಟ್ ಕಮ್ ಔಟ್ ಆಫ್ ದಿ ಕಮ್ಯುನಿಟಿ ಅಂತ ಇದೆ. ಸ್ಟ್ರಿಕ್ಟ್ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಇದುವರೆಗೂ ಆಗಿಲ್ಲ. However, a state before being granted de jure recognition must fulfill certain conditions such as reasonable assurance of stability and permanence. Government should command the general support of the population, and it should be able and willing to fulfill its international obligation. Then only the de facto recognition has to be given. The condition recognition of before the de jure recognition and in the middle of the de facto recognition, if the state subject to specific obligation, it is not fulfilled by that, and based on that the member state has to be give the some of the conditions. Based on that, those conditions, when it is has to be fulfilled by the state, then it can be recognized with the de jure. Coming to the distinction between de facto and de jure. First, de facto recognition is a provisional and factual recognition. De jure is a legal recognition, and de facto is granted when there is fulfillment of the essential conditions of the statehood. But de jure is granted when state fulfills all the essential conditions. Okay, de facto recognition is the primary step. The de jure recognition is the can be granted either with or without. Next, de facto recognition can either conditional or non-conditional, but de jure it is final and non-conditional recognition. De facto is revocable in nature, but de jure it is non-revocable. De facto recognition has given only the few rights and obligation, but when it comes to the de jure, it is an absolute right and obligation. De facto cannot undergo the state succession, but in the de jure recognition, the state can have the state succession. And de facto recognition cannot enjoy full diplomatic immunities, but in the de jure recognition, it can enjoy the diplomatic immunities. Coming to in Kannada, so ಡಿ ವಾಸ್ತವಿಕ ಸಿದ್ಧಾಂತ ಹೇಳ್ದೆ, ಯಾಕಂದ್ರೆ ಸ್ಟೇಟ್ಹುಡ್ ಇದ್ದಾಗ ಅದರ ಆಧಾರದ ಮೇಲೆ ಆ ರಾಷ್ಟ್ರ ಮನ್ನಣೆಯನ್ನ ಪಡೆಯುತ್ತೆ. ಹಾಗಾದ್ರೆ ಡಿ ಜೂರೆ ಅಂದ್ರೆ ಏನು? ಒಂದು ಸಲ ಒಂದು ರಾಷ್ಟ್ರ ಪೂರ್ಣ ಪ್ರಮಾಣದಲ್ಲಿ, ಅಂದ್ರೆ ಏನು ಡಿ ಫ್ಯಾಕ್ಟೋ ಅಲ್ಲಿ ಪಡೆದಿತ್ತು, ಸ್ಟೇಟ್ಹುಡ್ ಆದ್ಮೇಲೆ ಕಂಡೀಷನ್ಸ್ ಗಳನ್ನ ಹಾಕಿರ್ಬೋದು, ಆ ಷರತ್ತುಗಳನ್ನ ಪೂರೈಸಿ ಓಕೆ ಈ ರಾಷ್ಟ್ರವನ್ನ ಇವಾಗ ನಾವು ಮನ್ನಣೆ ಮಾಡ್ಬೋದು, ನಮ್ಮ ಕಮ್ಯುನಿಟಿ ಒಳಗೆ, ಅಂತಾರಾಷ್ಟ್ರೀಯ ಕಮ್ಯುನಿಟಿ ಒಳಗೆ ನಾವು ತಗೊಳ್ಬಹುದು ಅಂತ ಆದ್ರೆ ಇದನ್ನ ತಗೊಳ್ಬಹುದು. ಬಟ್ ಇದು ಕೇವಲ ಹೊಸ ರಾಷ್ಟ್ರಗಳಿಗೆ ಅನ್ವಯ ಆಗುತ್ತೆ. ಈಗಾಗಲೇ ರಾಷ್ಟ್ರಗಳ ಮನ್ನಣೆ ಏನಾಗಿದೆ ಆ ರಾಷ್ಟ್ರಗಳಿಗೆಲ್ಲ ಹೊಸ ಮನ್ನಣೆಗಳಿಗೆ ಮಾತ್ರ ಈ ಡಿ ಫ್ಯಾಕ್ಟೋ ಡಿ ಜೂರೆನ ಯುನೈಟೆಡ್ ನೇಷನ್ ಫಾಲೋ ಮಾಡುತ್ತೆ. ಮೊದಲ 51 ರಾಷ್ಟ್ರಗಳು ಆಲ್ರೆಡಿ ಮನ್ನಣೆಯಲ್ಲಿ ಇದ್ವು, ಪದೇ ಪದೇ ಇದು ಚೇಂಜ್ ಆಗಲ್ಲ. ಸರ್ಕಾರಗಳು ಬದಲಾವಣೆ ಆಗ್ಬೋದು, ಆದ್ರೆ ಮನ್ನಣೆ ರಾಷ್ಟ್ರಕ್ಕೆ ಒಂದು ಸಲ ಮನ್ನಣೆ ಕೊಟ್ರೆ ಅದು ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಚೇಂಜ್ ಆಗೋದಿಲ್ಲ. ಹಾಗಾಗಿ ವಾಸ್ತವಿಕ ಸಿದ್ಧಾಂತಕ್ಕೂ ಮತ್ತು ಕಾನೂನಾತ್ಮಕ ಸಿದ್ಧಾಂತಕ್ಕೂ ಬಹಳ ವ್ಯತ್ಯಾಸ ಇದೆ. ವಾಸ್ತವಿಕ ಸಿದ್ಧಾಂತ ಏನು, ಇದು ಬರೀ ಒಂದು ಮೂಲತಃವಾದಂತಹ ಒಂದು ಮನ್ನಣೆ ಆಗಿರುತ್ತೆ. ಅದೇ ಕಾನೂನಾತ್ಮಕದಲ್ಲಿ ಇದು ಕಾನೂನಾತ್ಮಕ ಮನ್ನಣೆ, ಮತ್ತೆ ಇದು ಫೈನಲ್ ಕೂಡ, ಇರಿವೋಕಬಲ್, ಅಂದ್ರೆ ಇದನ್ನ ತೆಗೆಯೋಕ್ ಸಾಧ್ಯ ಇಲ್ಲ. ವಾಸ್ತವಿಕ ಮನ್ನಣೆಯಲ್ಲಿ ಅದು ಫುಲ್ಫಿಲ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದನ್ನ ತೆಗೆದು ಹಾಕ್ಬಹುದು. ಅದು ಪೂರ್ಣ ಪ್ರಮಾಣದ ಸ್ಟೇಟ್ ಹುಡ್ ಅನ್ನ ಇದ್ರೂ ಕೂಡ, ಎಸೆನ್ಷಿಯಲ್ ಇದ್ರೂ ಕೂಡ, ಅಲ್ಲಿ ರೆಕಗ್ನಿಷನ್ಗೆ ವಾಸ್ತವಿಕ ಮನ್ನಣೆಯಲ್ಲಿ ಅದು ಕೆಲವೊಂದು ಕಂಡೀಷನ್ಸ್ ಗಳನ್ನ ಹಾಕ್ತಾರೆ. ಯಾಕಂದ್ರೆ ಗವರ್ನಮೆಂಟ್ ಆಗಿರ್ಬೋದು ಅಥವಾ ಮತ್ತೆ ಇನ್ಯಾವುದೋ ರೀತಿಯಲ್ಲಿ ಅವ್ರ ಭೂಪ್ರದೇಶದ ವ್ಯಾಪ್ತಿಯನ್ನ ಸರಿಯಾಗಿ ಕೊಟ್ಟಿರಲ್ಲ, ಆ ತರದಲ್ಲಿ ಆ ಕಂಡೀಷನ್ಸ್ ಗಳನ್ನ ಫುಲ್ಫಿಲ್ ಮಾಡ್ಬೇಕು. ಬಟ್ ಡಿ ಜೂರಿಯಲ್ಲಿ ಅದೆಲ್ಲ ಕಂಡೀಷನ್ ಫುಲ್ಫಿಲ್ ಆದ್ಮೇಲೆ ಕೊಡ್ತಾರೆ. ಹಾಗೆ ವಾಸ್ತವಿಕ ಸಿದ್ಧಾಂತದಲ್ಲಿ ಕೆಲವೊಂದು ರೈಟ್ಸ್ ಅಂಡ್ ಆಬ್ಲಿಗೇಷನ್ಸ್ ಇರುತ್ತೆ. ಅಂದ್ರೆ ಪೂರ್ಣ ಪ್ರಮಾಣದ ಅಬ್ಸಲ್ಯೂಟ್ ಕಡ್ಡಾಯವಾದಂತಹ ಒಂದು ಹಕ್ಕುಗಳು ನಮಗೇನು ಒಂದು ಸಲ ನಾವು ರೆಕಗ್ನೈಸ್ ಆದ್ಮೇಲೆ ನಮಿಗೂ ಕೂಡ ಅಬ್ಸಲ್ಯೂಟ್ಸ್ ರೈಟ್ಸ್, ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಎಲ್ಲ ಹೇಗೆ ಬಂದಿದೆಯೋ ಆ ತರ ರೈಟ್ಸ್ ಗಳು ಇರೋದಿಲ್ಲ ವಾಸ್ತವಿಕ ಮನ್ನಣೆಯಲ್ಲಿ. ಕೇವಲ ಕೆಲವು ರೈಟ್ಸ್ ಗಳಿಗೆ ಮಾತ್ರ ಸೀಮಿತ ರೈಟ್ಸ್ ಗಳಿರುತ್ತೆ. ಆದ್ರೆ ಒಂದು ಸಲ ಡಿ ಜೂರೆ ಅಂದ್ರೆ ಕಾನೂನಾತ್ಮಕವಾಗಿ ಆದ್ರೆ ಅಬ್ಸಲ್ಯೂಟ್ ರೈಟ್ಸ್ ಅಂಡ್ ಆಬ್ಲಿಗೇಷನ್, ಹೊಣೆಗಾರಿಕೆ ಅವ್ರಿಗೆ ಇದ್ದೇ ಇರುತ್ತೆ. ಮತ್ತೆ ವಾಸ್ತವಿಕ ಮನ್ನಣೆಯಲ್ಲಿ ಅವರಿಗೆ ಸಕ್ಸೇಷನ್ ರೈಟ್ಸ್ ಇರೋದಿಲ್ಲ ಯಾವುದೇ ರಾಷ್ಟ್ರಕ್ಕೆ. ಅಂದ್ರೆ ಬೇರೆ ಒಂದು ರಾಷ್ಟ್ರದಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಒಂದು ಸ್ವಾಧೀನತೆನೆ ಪಡೆಯೋದು ಆಗಿರ್ಬೋದು, ಉತ್ತರಾಧಿಕಾರತ್ವವನ್ನ ಇದ್ ಮಾಡೋದು ಆಗಿರ್ಬೋದು. ಯಾಕಂದ್ರೆ ರಾಷ್ಟ್ರಗಳು ಕೂಡ ಮತ್ತೊಂದು ರಾಷ್ಟ್ರದ ಒಂದು ಪ್ರಾಪರ್ಟಿಯನ್ನ ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ನಾವು ತಗೊಳ್ಬಹುದು. ಸೊ ಆದ್ರೆ ಅದೆಲ್ಲ ವಾಸ್ತವಿಕ ಮನ್ನಣೆಯಲ್ಲಿ ಸಿಗೋದಿಲ್ಲ. ಒಂದು ಸಲ ಕಾನೂನಾತ್ಮಕ ಮನ್ನಣೆ ಇದ್ರೆ ಮಾತ್ರ ಅದು ಸಿಗುತ್ತೆ. ಮತ್ತೆ ರಾಯಭಾರತ್ವದ ಇಮ್ಯುನಿಟೀಸ್ ಏನಿದೆ ಅದು ವಾಸ್ತವಿಕ ಮನ್ನಣೆಯಲ್ಲಿ ಸಿಗೋದಿಲ್ಲ. ಅದೆಲ್ಲ ಸಿಗುವಂಥದ್ದು ಕೇವಲ ಕಾನೂನಾತ್ಮಕವಾದ ಮನ್ನಣೆಯಲ್ಲಿ. ಸೊ ಹಾಗಾದ್ರೆ ಫಾರ್ಮ್ಸ್ ಆಫ್ ರೆಕಗ್ನಿಷನ್, ಹೇಗೆ ರೆಕಗ್ನೈಸ್, ವಾಟ್ ಆರ್ ಆಲ್ ದ ಫಾರ್ಮ್ಸ್ ದೇ ಯೂಸ್ಡ್ ವೈಲ್ ಗಿವಿಂಗ್ ದೀಸ್ ಟೈಪ್ಸ್ ಆಫ್ ದಿ ರೆಕಗ್ನಿಷನ್. ದೇರ್ ಇಸ್ ಎಕ್ಸ್ಪ್ರೆಸ್ಡ್ ಅಂಡ್ ಇಂಪ್ಲೈಡ್. It is connected with the same de facto and de jure, but they are giving some extra explanation with regard to the how they will be give the recognition. Then what is expressed recognition? When an existing state recognizes a new state expressly through official declaration or notification, it is considered to the expressed form of government recognition. Express recognition can made through any express or formal means such as a sending and publishing declaration or a statement in the opposite party. When a state is recognized by the expressed ways, it is a de jure recognition unless provided otherwise by the recognizing state in the declaration. Then implied recognition means the state recognizes newly formed state through any implied act, then it is considered to the implied recognition. It can be granted through any implied means. The current state treats the newly formed state as an international person. The implied credit not granted through any official notification or a declaration. The recognition through implied means varies from case to case. ಈ ಇಂಪ್ಲೈಡ್ ರೆಕಾಗ್ನಿಷನ್ ಇಲ್ಲಿ ವ್ಯಕ್ತ ಮತ್ತು ಅವ್ಯಕ್ತ ಇದೆಯಲ್ಲ, ಡಿ ಜೂರೆ ಮತ್ತೆ ಡಿ ಫ್ಯಾಕ್ಟಿಗೂ ಅದು ಕನೆಕ್ಟಿವಿಟಿ ಇರುತ್ತೆ. ಇಲ್ಲಿ ವ್ಯಕ್ತವಾದಂತಹ ಸಿದ್ಧಾಂತದಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ, ಆಯ್ತು ನಿನ್ನನ್ನ ನಾನು ರೆಕಗ್ನೈಸ್ ಮನ್ನಣೆಯನ್ನ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂದ್ರೆ ಆ ರಾಷ್ಟ್ರದೊಂದಿಗೆ ಡಿಕ್ಲರೇಷನ್ ಘೋಷಣೆ ಮಾಡೋದು ಅಥವಾ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಅನೌನ್ಸ್ ಮಾಡೋದು, ಈ ಒಂದು ರಾಷ್ಟ್ರಕ್ಕೆ ನಾವು ಮನ್ನಣೆ ಕೊಟ್ಟಿದೀವಿ ಅಂತ. ಸೊ ಆ ಮೂಲಕ ಅವರು ತಿಳಿಸ್ತಾರೆ ಅಫಿಷಿಯಲಿ ಲೆಟರ್ಸ್ ಮೂಲಕ. ಆದ್ರೆ ಇಂಪ್ಲೈಡ್ ಅಲ್ಲಿ ಅವ್ಯಕ್ತವಾಗಿ ತಿಳಿಸಲ್ಲ. ಆದ್ರೆ ಆ ರಾಷ್ಟ್ರದೊಂದಿಗೆ ನೀನೊಂದು ರಾಷ್ಟ್ರ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ. ಅವರು ಮೆಂಬರ್ಶಿಪ್ ತಗೊಳ್ತಾರೋ ಬಿಡ್ತಾರೋ, ಬಟ್ ಆದ್ರೆ ನೀನೊಂದು ರಾಷ್ಟ್ರ ಅಂತ ರೆಕಗ್ನೈಸ್ ಮಾಡ್ತಾರೆ. ಹೆಂಗೆ ಅಂದ್ರೆ ಒಪ್ಪಂದಗಳು ಮಾಡ್ಕೊಳ್ಳೋದು ಅಥವಾ ಅವ್ರ ನಡುವೆ ಒಂದು ವ್ಯವಹಾರಗಳನ್ನ ಮಾಡ್ಕೊಳ್ಳೋದು, ಆ ತರದಲ್ಲಿ ದೇ ಕ್ಯಾನ್ ಗೋ ವಿತ್ ದಿ ರೆಕಗ್ನಿಷನ್. There is a case that is Luther versus Sagar in 1921. British courts recognized Soviet decrees only after the UK recognized the USSR. See here, UK ಯಾವಾಗ USSR ನ ರೆಕಗ್ನೈಸ್ ಮಾಡ್ತು ಅವಾಗ ಮಾತ್ರ ಈ ಸೋವಿಯತ್ ಬ್ರಿಟಿಷ್ ಕೋರ್ಟ್ಸ್ ರೆಕಗ್ನೈಸ್ ಮಾಡ್ತಾ ಬಂತು. ಶೋಸ್ ದಟ್ ರೆಕಗ್ನಿಷನ್ ಹ್ಯಾಸ್ ಲೀಗಲ್ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್ in the domestically. Next, in the case of Bank of Ethiopia versus National Bank of Egypt in 1937, these are all the cases, earlier cases. These are all the cases before when the League of Nations has to be there, how the recognition has to be determined, and based on that, I have taken some of the cases which quoted by the authors. In Bank of Ethiopia, recognition determines whether acts of foreign government are valid in domestic courts. Supports of the importance recognition has to be validating by the foreign courts, because as we know that so we followed by some foreign courts judgment and other things, right? So based on that, how they are recognizing though their states based on the doctrines which I have explained in the UK Strada and Toboro doctrine, how they are given the highlight with the in the what criteria we need to recognize by the state. Based on that, they also recognize if the state, one state has to be recognized by the newly state, then automatically other state, the neighbor state also recognizes it. Okay, that state is already recognized. It means that that state, the B state, has to be fulfilled all the conditions. So that's why A state has to be recognized. Then C state automatically recognize the B states, like that. Okay. When come to the government recognition, what is government recognition? Anybody? ಇದುವರೆಗೆ ಅರ್ಥ ಆಯ್ತಾ? Anybody have any question on this one? Anybody? Hello?
No, ma'am, we are good.
Yeah. Okay.
ಕನ್ನಡದ ಉಚ್ಚಾರಣೆ ಬಹಳ ಸ್ಪಷ್ಟವಾಗಿದೆ ಮೇಡಮ್.
Thank you, sir. Thank you. Okay. Then come to the recognition of government. For any statehood, the government is an important element when a state is formed. Its government changes from time to time. When the government changes as an ordinary course of political action, the recognition of government by the existing state is not required. But when the government changes due to any revolution, then its recognition by the existing state is required. See, the revolution is very important here. If the government changes based on the revolution, then once again that the state has to be go for the recognition aspect. If the government also consequently changes by the political action, then no need for the recognized once again in the international community. For the recognizing the new government established out of revolution, the existing state need to consider that the new government have the sufficient control over the territory and its people or not. And ವಸಂತ್ ರೇಸ್ ಮಾಡಿದ್ರು. ಎಸ್
ಹೌದು ಮೇಡಮ್, ಈಗ ವೆರಿ ರೀಸೆಂಟ್ಲಿ ನೇಪಾಳದಲ್ಲಿ ಗಲಾಟೆ ಆಯ್ತು ಗೊತ್ತಾ?
ಹಾ ಹೇಳಪ್ಪ.
ಆಗ ರಾತ್ರಿ ಅಂದ್ರೆ ಐ ಮೀನ್ ಟು ಸೇ ಒಂದು 3 ದಿವಸದೊಳಗಡೆ ಇಡೀ ಗೌರ್ಮೆಂಟೇ ತಲೆ ಕೆಳಗಾಗೋಯ್ತು.
ಚೇಂಜಸ್ ಆಗೋಯ್ತು.
ಹೌದು. ಅಂತ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ಅವ್ರು ತಿರ್ಗಾ ರೆಕಗ್ನಿಷನ್ ಹೋಗ್ಬೇಕಾಗತ್ತಾ?
ಸರ್, ಅಲ್ಲಿ ರೆವಲ್ಯೂಷನರಿ ಆದ್ರೂ ಅವ್ರದ್ದು ಏನಿದೆ ಅಂದ್ರೆ ರಾಜ ಮನೆತನದ ಅಧಿಕಾರ, ಕ್ವೀನ್. ಆ ಕ್ವೀನ್ ಆಲ್ರೆಡಿ ರೆಕಗ್ನೈಸ್ಡ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ, ನೇಪಾಳ ಅಂತ. ಸೊ ಅದು ರಾಜ ಮನೆತನದಲ್ಲಿ ಮನೆತನದೊಳಗೆ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು. ಅದು ಹೊರಗಡೆ ನಮ್ಮ ಪಬ್ಲಿಕ್ ಅಲ್ಲಿ ಆಗ್ಲಿಲ್ಲ ಅದು, ಅಲ್ವಾ? ಅವನು ಮನೆ ಒಳಗೆ ಅವರು ಇದು ಮಾಡಿದ್ದು. ಮನೆ ಒಳಗೆ ಆದಾಗ ಆ ಒಂದು ಇದ್ರ ಮೇಲೆ ಪಬ್ಲಿಕ್ ರೇಸ್ ಮಾಡಿದ್ರು, ಅವ್ರು ಅದನ್ನ ಸಾರ್ಟ್ ಔಟ್ ಮಾಡ್ಕೊಂಡ್ರು. ಯಾವಾಗ ಅದು ಪಬ್ಲಿಕ್ ಅಲ್ಲಿ ಆಗುತ್ತೆ, ಪಬ್ಲಿಕ್ ವಿಲ್ ಟೇಕ್ ಅನ್ ಆಕ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ ದ ಗವರ್ನಮೆಂಟ್, ದೆನ್ ಡೆಫಿನೆಟ್ಲಿ ದೇ ಹ್ಯಾವ್ ಟು ಗೋ. ಯಾಕಂದ್ರೆ ಅದರ್ ಸ್ಟೇಟ್ ವಿಲ್ ನಾಟ್ ರೆಕಗ್ನೈಸ್. ಆ ಬೇರೆ ರಾಷ್ಟ್ರಗಳು ಅಷ್ಟು ಈಸಿಯಾಗಿ ಬಿಡೋದಿಲ್ಲ ನೀವ್ ಇದನ್ ಮಾಡಿ ಅಂತ. ಅದಕ್ಕೆ ಕಂಡೀಷನ್ಸ್ ಗಳು ಹಾಕ್ತಾ ಹೋಗ್ತಾರೆ. ಕೆಲವೊಂದು ಏನು ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕಮ್ಯುನಿಟಿಯಿಂದ ಸಹಾಯ ಬರ್ಬೇಕು, ಅದಕ್ಕೆಲ್ಲ ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಆಗುತ್ತೆ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಟೇಕ್ ಇಟ್ ಎಕ್ಸಾಂಪಲ್ ಆಫ್ ಪಾಕಿಸ್ತಾನ್ ಇಟ್ ಸೆಲ್ಫ್. ಪಾಕಿಸ್ತಾನ ಯಾವಾಗ ಅವನು ಅರ್ಲಿಯರ್ ಇವ್ರು ಇದ್ರಲ್ಲ ಮುಷ್ರಫ್, ಅವರು ಮಿಲಿಟರಿ ಆಡಳಿತ ತಗೊಂಡಾಗ ಅದೇ ಅವರಿಗೆ ಕಂಡೀಷನ್ಸ್ ಗಳನ್ನ ಹಾಕಿದ್ದು. ಅದರಲ್ಲೂ ಕೂಡ ಪರ್ಮನೆಂಟ್ ಮೆಂಬರ್ಸ್ USSR ಅವರು ಮತ್ತೆ USA, ಈ ಕಡೆ USSR ನಮಗ್ ಕೊಡ್ತಾ ಇದ್ರು ಬೆಂಬಲನ. ಆಕ್ಚುಲಿ USA ಇತ್ತೀಚೆಗೆ ನಮಗ್ ಕೊಡ್ತಿದೆ, ಬಟ್ ಮೊದ್ಲಿಂದನೂ ಅದು ಬೆಂಬಲ ಇರೋದೇ ಪಾಕಿಸ್ತಾನಕ್ಕೆ, ಅಮೆರಿಕದು. ಸೊ ಹಾಗಾಗಿ ಆ ಒಂದು ಪರ್ಮನೆಂಟ್ ನೇಚರ್ ಇದ್ದಿದ್ರಿಂದ ಆ ರಾಷ್ಟ್ರಕ್ಕೆ ಎಷ್ಟೇ ಕಂಡೀಷನ್ಸ್ ಆಗ್ತಾ ಹೋದೋ ಆ ರಾಷ್ಟ್ರ ಇರ್ತಾ ಬಂತು. ಬಟ್ ಆದ್ರೆ ಯುನೈಟೆಡ್ ನೇಷನ್ ಅಲ್ಲಿ ಅದಕ್ಕೆ ಯಾವಾಗ್ಲೂ ಬ್ಲಾಕ್ ಮಾರ್ಕ್ ಇತ್ತೇ ಇರ್ತಿತ್ತು. ಇಲ್ಲ, ಇದನ್ನ ನಾವು ಒಪ್ಕೊಳ್ಳಲ್ಲ ನೀವ್ ಹೇಳಿದ್ರು ಅಂತ. ಅವಾಗ ಅವರು ಇಲ್ಲ ನಾವೇ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀವಿ ಅಂತ ಮಿಲಿಟರಿ ಆಕ್ಷನ್ ಅವರು, ದೆನ್ ದೇ ಹ್ಯಾವ್ ಗಿವನ್ ಸರ್ಟೈನ್ ಥಿಂಗ್ಸ್, ದೆನ್ ಓನ್ಲಿ ದಟ್ ಕುಡ್ ಬಿ ರೆಕಗ್ನೈಸ್ಡ್ ಆಸ್ ಎನ್ ಬೇಸ್ಡ್ ಆನ್ ದಿ ಮಿಲಿಟರಿ ಆಕ್ಷನ್ ಅಂತ. ಬಟ್ ಆಟೋಮೆಟಿಕ್ಲಿ ಅದು ಯಾವಾಗ ಪೊಲಿಟಿಕಲಿ ಇದಾಯ್ತು. ಮರಿಯಪ್ಪ ಏನೋ ಹೇಳ್ತಾ ಇದಾರೆ. ಮರಿಯಪ್ಪ ಏನೋ ಕ್ವಶನ್ಸ್ ಏನೋ ಹಾಕಿದ್ರಿ, ಮೆಸೇಜ್ ಹಾಕಿದ್ರಿ.
ಮೇಡಮ್, ಇದು ರೀಸೆಂಟ್ ಆಗಿ ಇಲ್ಲಿ ನಿಮ್ಗೆ ಗೊತ್ತಿರ್ಬೋದು, ನಿತ್ಯಾನಂದ ಇಲ್ಲಿಂದ
ಅದನ್ನ ಬರ್ತೀನಿ ಸರ್, ಕೊನೆಗೆ ಬರ್ತೀನಿ.
ಓಡೋಗಿ ಕೈಲಾಸ ಅಂತ ಇದು ಮಾಡಿ ಅದು ರೆಕಗ್ನೈಸ್ ಆಗಿದೆ. ಅವ್ರದೇ ಓನ್ ಕಂಟ್ರಿ, ಓನ್ ಕರೆನ್ಸಿ ಎಲ್ಲ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಸೊ ಬಟ್ ರೆಕಗ್ನೈಸ್ ಆಗಿದೆ ಇಲ್ಲೋ ಅಂತ
ಹೇಳ್ತೀನಿ ಸರ್. ಅದಿದೆ ಐ ಎಕ್ಸ್ಪೆಕ್ಟೆಡ್ ಕ್ವಶನ್, ಯಾಕಂದ್ರೆ ರೀಸೆಂಟ್ ಆಗಿ ಅದು ನ್ಯೂಸ್ ಪೇಪರ್ ಅಲ್ಲೆಲ್ಲ ಬಂತು. ಎಕ್ಸ್ಪೆಕ್ಟೆಡ್. ಐ ವಿಲ್ ಟೆಲ್ ಇಟ್ ಇನ್ ದ ಲಾಸ್ಟ್.
Sorry for interruption, ma'am.
Yes. Yeah, Lalita, please.
Please, everyone, keep your questions. At last, we are going to clarify here all the doubts.
Yeah.
Please don't interpret in the middle and disturb the seminars, please.
Yeah. Coming to the recognition of government. So as I stated, the new government have sufficient control over the territory and its people or not. The new government is willing to fulfill the international duties and obligations or not. These two conditions, every time the state has to be give the letter to the international community whenever, even in the politically changes or anything, they have to be give awareness. The declarationary note has to be give to the international community that, so the politically changes, in any type of changes, they have to be give that, yes, we are willing to control our territory and we are willing to fulfill international duties, hence the recognition has to be continued as it is. Okay, so with this satisfaction the government will goes for that. For example, you take it as a tree. Seasonally ಇದಾದ ತಕ್ಷಣ ನಿಮ್ಗೆಲ್ಲರಿಗೂ ಗೊತ್ತು, ಇವಾಗ ಚಳಿ ನಮ್ಮಲ್ಲೂ ಕೂಡ 4 ಕಾಲಗಳು ಇವಾಗ ಬದಲಾವಣೆ ಹಾಗೆ ಮರಗಳು ಅಷ್ಟೇ. ಕೆಲವೊಂದು ಕಾಲದಲ್ಲಿ ಮರಗಳೇನಾಗುತ್ತೆ, ಎಲೆಗಳು ಉದ್ರೋಗುತ್ತೆ, ತಂತಾನೆ ಮತ್ತೆ ಹೊಸದಾಗಿ ಚಿಗುರೊಡೆಯುತ್ತೆ. ಇದೇ ತರ ಇವನ್ ಮನ್ನಣೆಯಲ್ಲೂ ಅಷ್ಟೇ. ಮರ ಯಾವಾಗ ಮನ್ನಣೆ ಒಂದು ಸಲ ಡಿಜೂರೆ ರೆಕಗ್ನಿಷನ್, ಇಟ್ ಈಸ್ ಲೈಕ್ ಎ ಟ್ರೀ. ಈವನ್ ದ ಲೀವ್ಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಫಾಲ್ ಡೌನ್, ದಟ್ ಈಸ್ ದ ಪೊಲಿಟಿಕಲಿ ಆರ್ ಎನಿ thing, it can be followed, but mara the tree has to be maintained by itself. Like that, ಯಾವಾಗ ಮರ ತಂತಾನೆ ಮನ್ನಣೆಯನ್ನ ಇರುತ್ತೆ, ಬಟ್ ಲೀವ್ ಹೋಗುತ್ತೆ, ಹೊಸದ್ ಬರುತ್ತೆ. ಹಾಗೆ ಅದು ಆ ಮರನ ಮರ ಅಂತ ನಾವು ಕರೀದಲೇ ಇರೋದಿಲ್ಲ. ಓಕೆ, ಮಾವಿನ ಮರ ಅಂದ್ರೆ ಮಾವಿನ ಮರನೇ ಹೇಳ್ತೀವಿ. ಅದು ಎಲೆ ಉದ್ರಿ ಅದ್ರಲ್ಲಿ ಬೇವಿನ ಮರ ಬರ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ವಾ, ಅಥವಾ ಇನ್ಯಾವುದೋ ಇಲ್ಲ, ಬಟ್ ಮರನ ನಾವು ರೆಕಗ್ನೈಸ್ ಮಾಡೋದು ಇದ್ದೇ ಇರುತ್ತೆ ಅಲ್ವಾ. ಹಾಗಾಗಿ ಸೊ ಅದು ಬಿದ್ದೋದ್ರೆ ಮಾತ್ರ ಪೂರ್ಣ ಪ್ರಮಾಣದಲ್ಲಿ ಇಟ್ ಈಸ್ not to be willing to fulfill the international conditions and it has taken out of the community, then only that state will not recognize, or else the state could be recognized. So duty to recognize, then what to whom have the duty to recognize? The duty towards the states. those who are in the international community, generally recognized with the possessors of essential requisite of the statehood. And international law, it imposes upon the state to grant recognition to such a state. However, they do not accept any such obligation. Since the act of recognition is considered as a diplomatical tool, function of recognizing state is said to be a political diplomatic action or the function. The granting of recognition depends on purely discretionary of the each state. Nobody can by force can state that you can recognize. It is discretionary part of the states. Sometimes state grant recognition to the new state to establish diplomatic relations with it. This may lead to premature act if the new state has not fulfilled this type of the recognition or the conditions of the statehood. However, international law does not consider such an act of premature recognition to be its violation. Since it depends upon the discretion of the state, it can continue with those state diplomatic things or anything. Okay, yes. Then collective recognition, it means that recognition in the group of state collectively. For example, take it examples of the United Nation General Assembly. When a state is to be admitted as a new member, a voting procedure has to be held by the General Assembly. 2/3 majority, those who are present before the General Assembly, and they have to be given vote towards the state. Either it is a new state, has to be recognized by the General Assembly as a collectively. So this has to be recognized UN, that is United Nations, by the European Union. Example, admission to the United Nations indicates the collective recognition. So now 193 states has to be there. So if new state like Kailasa or other state, they wanted to give an state, then automatically all the states members who are present in the United Nations, they have to be recognized. Okay, that is, we call it as a collectively recognition. Then what is the consequences of legal recognition or legal effects of recognition? Yeah, the recognized state acquires the capacity to enter into a diplomatic relations with the other state and to sign treaties with them. The recognized state becomes entitled to sue in the courts of the recognizing states. The courts of the recognizing state give effect to the past as well as present legislation and executive acts of the recognized state. Entities can participate in the international law, and it confirms sovereignty and immunities over it, and it has acquired treaty making power. Along with it acquire rights and duties of the rules of international law relating to privileges and immunities. Okay, it recognized state is entitled to sovereign immunity, and it is entitled to the succession and possessions of the property situation in the territory of the recognizing state, increase stability at home and prestige abroad, provide access to foreign aid, loans and trade. These are all the effects of recognition of the state. ಮನ್ನಣೆ ಅಂತ ಪಡೆದಾಗ ಆ ರಾಜ್ಯ ಮತ್ತೊಂದು ರಾಷ್ಟ್ರದ ಜೊತೆ ಡಿಪ್ಲೊಮ್ಯಾಟಿಕ್ ರಿಲೇಶನ್ಶಿಪ್ ಅಂದ್ರೆ ರಾಯಭಾರತ್ವವನ್ನ ಮಾಡಬಹುದು. ಜೊತೆಗೆ ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ತನ್ನನ್ನು ತಾನು ಸದಸ್ಯತ್ವದ ರೀತಿಯಲ್ಲಿ ಅಥವಾ ತನ್ನನ್ನು ತಾನು ರಾಜ್ಯ ಅನ್ನುವ ರೀತಿಯಲ್ಲಿ ಮತ್ತೊಂದು ರಾಷ್ಟ್ರದ ಜೊತೆ ವ್ಯವಹಾರಗಳನ್ನ ನಡೆಸಬಹುದು. ಸಾರ್ವಭೌಮತ್ವವನ್ನ ಅದು ತಗೊಳುತ್ತೆ. ಜೊತೆಗೆ ಕೆಲವೊಂದು ಇಮ್ಯುನಿಟೀಸ್ ಅಂದ್ರೆ ಮಾನ್ಯತೆಗಳನ್ನ ಅಂದ್ರೆ ಮನ್ನಣೆಗಳ ಜೊತೆಯಲ್ಲಿ ಕೆಲವೊಂದು ಸಹಾಯಗಳ ಇಮ್ಯುನಿಟಿ ಅಂತ ಹೇಳಿದ್ರೆ ನಾವೇನ್ ಹೇಳ್ತೀವಿ, ನಾನು ಲೀಗಲ್ ವರ್ಡ್ ಅದು ನನಗೆ ಮರ್ತೋಗ್ತಾ ಇದೆ. ಇಮ್ಯುನಿಟೀಸ್ ಅಂತ ಹೇಳಿದ್ರೆ ಸೌಲಭ್ಯಗಳು ಅಂತ ಬರುತ್ತೆ. ಜೊತೆಗೆ ಟ್ರೀಟಿ ಮೇಕಿಂಗ್ ಪವರು ಕೂಡ ಇರುತ್ತೆ. ಅಂದ್ರೆ ಒಪ್ಪಂದಗಳನ್ನ ಉನ್ಮುಕ್ತಿಗಳು. ಇಮ್ಯುನಿಟೀಸ್ ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ನಥಿಂಗ್ ಬಟ್ ಉನ್ಮುಕ್ತಿಗಳಂದ್ರೆ ಯಾವುದೇ ಕ್ರಿಮಿನಲ್ ಅಪರಾಧ ಇರ್ಬೋದು ಅಥವಾ ಮತ್ಯಾವುದೋ ಸಿವಿಲ್ ಅಪರಾಧಗಳಲ್ಲಿ ಒಂದು ಸಲ ರಾಯಭಾರತ್ವ ರಿಲೇಶನ್ಶಿಪ್ ಅನ್ನ ನಾವು ಮಾಡ್ಕೊಂಡಿದೀವಿ ಅಥವಾ ರಾಯಭಾರತ್ವಕ್ಕೆ ನಾವು ಒಳಗೊಂಡಿದೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ ಕೆಲವೊಂದು ಉನ್ಮುಕ್ತಿಗಳನ್ನ ಕೊಡ್ತಾರೆ ಆ ರಾಯಭಾರಿಗಳಿಗಿರ್ಬೋದು, ಆ ರಾಷ್ಟ್ರಗಳಿಗಿರ್ಬೋದು. ಅಂದ್ರೆ ನಿಮ್ಮನ್ನ ಯಾವುದೇ ರೀತಿಯಾದಂತಹ ಸಿವಿಲ್ ಅಥವಾ ಕ್ರಿಮಿನಲ್ ಧಾವೆಗಳಲ್ಲಿ ನಾವು ವಿಚಾರಣೆ ನಡೆಸಲ್ಲ, ನಿಮ್ಮ ರಾಷ್ಟ್ರಗಳಿಗೆ ಕಳಿಸ್ತೀವಿ. ಅಥವಾ ಕೆಲವೊಂದ್ರಲ್ಲಿ ನಿಮಗೆ ಇಷ್ಟು ಉನ್ಮುಕ್ತಿಗಳನ್ನ, ಈಗ ನಾವು ಹೇಗೆ CM ಇರ್ಬೋದು, PM ಇರ್ಬೋದು, ಅವರು ಬಂದ ತಕ್ಷಣ ಪೊಲಿಟಿಕಲ್ ಲೀಡರ್ ಆದ ತಕ್ಷಣ ಕೆಲವೊಂದು ಉನ್ಮುಕ್ತಿಗಳಿಂದ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಕೊಟ್ಟಿದೀವಿ, ಹಾಗೆ ರಾಷ್ಟ್ರ ಅಂತ ಆದ ತಕ್ಷಣ ಆ ಉನ್ಮುಕ್ತಿಗಳನ್ನ ಇವರು ಬಳಸ್ಕೊಳ್ಬಹುದು. ಜೊತೆಗೆ ಸ್ವಾಧೀನತೆ ಹಕ್ಕುಗಳ ಜೊತೆಯಲ್ಲಿ ಉತ್ತರಾಧಿಕಾರತ್ವ ಹಕ್ಕುಗಳನ್ನ ನಾವು ಒಂದು ಸಲ ಮನ್ನಣೆಯನ್ನ ಪಡ್ಕೊಂಡಾಗ ಮತ್ತೊಂದು ರಾಷ್ಟ್ರದೊಂದಿಗೆ ಅಥವಾ ಮತ್ತೊಂದು ರಾಷ್ಟ್ರದ ಆಸ್ತಿಯಲ್ಲಿ ನಾವು ಉತ್ತರಾಧಿಕಾರತ್ವವನ್ನ ಅಂದ್ರೆ ಮತ್ತೊಂದು ರಾಷ್ಟ್ರನ ಪಡ್ಕೊಳ್ಬಹುದು ಅನ್ನೋದನ್ನ. ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಆಸ್ತಿಯನ್ನ ನೀವು ಕೊಂಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಅವಕಾಶ ಇರುತ್ತೆ, ಅವರು ಕೊಡ್ತಾರೆ, ಅಥವಾ ಸಕ್ಸೇಷನ್ ರೀತಿಯಲ್ಲಿ ತಗೊಳ್ಬೋದು. ಇದು ರೆಕಗ್ನೈಸ್ಡ್ ಆದ್ರೆ ಮಾತ್ರ, ಮನ್ನಣೆ ಆದ್ರೆ ಮಾತ್ರ. ಜೊತೆಗೆ ಸ್ಟೇಬಿಲಿಟಿ ಇರುತ್ತೆ, ಒಂದು ಸ್ವತಂತ್ರತೆ ಇರುತ್ತೆ, ಮತ್ತೆ ಸೀಮಿತತೆ ಅಂತ ಇರೋದಿಲ್ಲ. ನಾನು ಫುಲ್ಫಿಲ್ ಆಗಿ ಅಂದ್ರೆ ಡಿಜುರಿ ಆಗಿ ಕಾನೂನಾತ್ಮಕವಾಗಿ ಆಗಿದ್ದೀನಿ, ಸೊ ನಾನು ಏನೇ ಒಂದು ಕೆಲಸಗಳನ್ನ ನಾನು ಉತ್ತಮವಾಗಿ ನಡೆಸ್ಕೊಂಡು ಹೋಗ್ಬೋದು ಅನ್ನೋದನ್ನ ಆ ರಾಷ್ಟ್ರಕ್ಕೆ ಸಿಕ್ಕಂಗಾಗುತ್ತೆ. ಬಟ್ when it is consequences of non-recognition, if it is not recognized any state, then an unrecognized state cannot sue in the courts of recognizing state. Recognizing state ಅಲ್ಲಿ unrecognized state, for example ಕೈಲಾಸ ಅಂತ ಹೇಳ್ತಿದ್ದೀರಲ್ಲ, ಅದಿನ್ನೂ ರೆಕಗ್ನೈಸ್ ಆಗಿಲ್ಲ, ಅಲ್ಲಿ ಏನೇ ಗಲಾಟೆ ಆಯ್ತು ಅಥವಾ ಅವ್ರು ಏನೋ ಒಂದು ಸಂಬಂಧಗಳು ನಡೆಸ್ಕೊಂಡ್ರೆ ಆ ಸ್ಟೇಟ್ ರೆಕಗ್ನೈಸ್ ಆಗಿದ್ರೆ ಆ ಕೋರ್ಟಲ್ಲಿ ಅವ್ರು ಕೇಳ್ಕೊಳಂಗಿಲ್ಲ, ಪರಿಹಾರ ಕೊಡಿಸಿ ನಿಮ್ಮವರಿಂದ ಈ ತರ ನನಗೆ ತೊಂದರೆ ಆಗಿದೆ ಅಂತ. ಸೊ ದೇರ್ ಇಸ್ ನೋ unrecognized state cannot have the authority to sue in the courts of recognizing state, and a state which has not been recognized is not entitled to enter into a diplomatic relations. The non-recognizing states representative of the state which has not been recognized to possess immunities in the legal process of the foreign state, and such state are also not entitled to claim their property situated in the foreign state. So they cannot claim it. Okay, these are all consequences of the non-recognitions of the things. Then whether the recognition can be withdrawal, ವಾಪಸ್ ತಗೊಳ್ಬೋದಾ? Yes, withdrawal can be happened by the de facto recognition. The once recognition has to be given by the legally, it cannot be taken it back. But except some cases, state extinction or merger ಆಗಿದ್ದಾಗ the withdrawal can be happen. So withdrawal of de facto recognition under international law, when a state having de facto recognition but it failed to obtain the essential conditions which are given by the state's authorities, then it can be withdraw, that I am not coming to the community of the nations, but it remain as a state, but it is not recognized under the international community because it fulfilled the statehood. Some of the states are there, even though they are recognized as a state, but they are not the members of the United Nations. Please note that. So world anta helidre there is no 193 state, still states are there, okay, but they are not ready to come to the international community. Okay, next, these are all the things which I am discussing. Those states they want under the international community, they need to go for these actions. Next, withdrawal of de jure recognition. Withdrawal of de jure recognition is a debatable topic under international. Till now, once the de jure recognition has to be happen, it is irrevocable, no one has to be taken it, even if it is go for the strictly interpretation like our Supreme Court or anything. So it can be happen, because if the state is not interested, ನಾವು ಇವಾಗ ಗಂಡ ಹೆಂಡತಿ ನಡುವೆನ ಅವ್ರ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಡೈವೋರ್ಸ್ ಅನ್ನ ತಗೊಳ್ತೀವಿ. ಆಗ ಇಫ್ ದ ಕಮ್ಯುನಿಟಿ ಅಂಡರ್ ದಿ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕಮ್ಯುನಿಟಿ ಸ್ಟೇಟ್ ಡು ನಾಟ್ ವಾಂಟ್ ಟು ಮೇಕ್ ಇಟ್, ಅದು ಹೋಗಬಹುದು ಅನ್ನೋದನ್ನ ಕೊಟ್ಬಿಟ್ರೆ, ದೆನ್ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಆಲ್ರೆಡಿ ಅಂಡರ್ ದಿ ಇಂಟರ್ನ್ಯಾಷನಲ್ ದೇರ್ ಇಸ್ ನೋ ಕೋಡಿಫೈಡ್ ಲಾಸ್. ಸೊ ದ peace and the United Nations we created because to maintain the peace. That's why they are made some strict regulation that once the state has to be de jure recognition, they cannot go for the withdrawal of the recognition. Okay, so go for the other two important case laws, then I will wind up. In Somalia versus Woodhouse, that is I already discussed the case. Somalia versus Woodhouse, Drake and Carey case in the UK in 1993. Only the government recognized by the UK can sue in UK courts. Useful thing is, when the UK courts only recognized as a part of some of the Tobo doctrine or anything, then they can, so as I stated you, recognizing state, while giving the consequences, I stated you that no. So only the recognized state which is recognized, they can claim in the recognizing state. If the consequences, the state is not recognized, it cannot have the right to claim in the recognizing courts. That has to be discussed in the Somalia, in the Woodhouse dark cases, because Somalia is not recognized by the UK, hence the Somalia has not authority to claim and take the opportunity to take the any remedy for the UK courts. It was clearly mentioned by the court of law. Next, Call Jesus Stefan versus Rainer and Keller Limited. This is also considered in the UK court. Concerned that East German region, which is the UK, did not recognize. So hence East German region will not have the authority for the claiming the UK courts, because the government is also not recognized. Then come to the Tinoco arbitration, that is Great Britain versus Costa Rica, that I have mentioned in my PPT also in 1923. It is a leading case. Recognition is declaratory regime may exist even if it is not recognized. Acts of unrecognized government may still be valid if they exercise effective control. See, I stated you, the state, once how the government, newly formed government has to be recognized, they have to be give the two important conditions, that we are ability to control our population and the territory, and we are ready to come with the international relations. If they prove that, even they not recognized, but by the way of declaratory, the governments has to be remain as it is, and the state also recognized, because in the Tinoco arbitration it has to be mentioned by the UK. Next, Western Sahara advisory opinion. In this case, recognition issued linked to the self-determination. The International Court of Justice held that Spanish withdrawal did not make Western Sahara terra nullius, widely cited by the invalid recognition of the territorial acquisition. Acquisition tashna, you will not to be taken as a condition to part of the international thing. Next, in the Namibia advisory opinion, that is ICJ in 1971, it is stated that UN Security Council has to be declared the South Africa's presence in Namibia, that is illegal, because South Africa, as I stated earlier also, in Montrevico thing, the Japanese influence is more in the Montrevico. Because of that state is not recognized. Here also the UN Security Council declares South Africa's influence in more in Namibia, but it is in illegal way. So that's why Namibia is also not recognized, and state were obligated to recognize the illegal situations. Hence, and based on those aspects also, the recognition will not to be given to things. Then Åland Islands case, that is conditions for recognition, that is League of Nations in 1920, it was decided. One of the earliest decision on self-determination and recognition. Recognition cannot be given if it is prompts succession without valid ground. ವ್ಯಾಲಿಡ್ ಗ್ರೌಂಡ್ ಇಂದ ಇಲ್ಲದೆ ಇದ್ರೆ ಐಲ್ಯಾಂಡ್ಸ್ ಗಳನ್ನ, ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಅಂಡರ್ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಲಾ, ಐಲ್ಯಾಂಡ್ಸ್ ಗಳ ಮೇಲೆ ನಾವು ಪ್ರಭುತ್ವವನ್ನ ಸಾಧಿಸಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ, ಅಥವಾ ಮನ್ನಣೆಯನ್ನ ಪಡಿಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ, ಅಲ್ಲಿ ಮೊದಲು ಅಂದ್ರೆ ಲಾ ಆಫ್ ದಿ ಸಿ ಅಲ್ಲಿ ನಾವು ಇದನ್ನ ನೋಡ್ತಾ ಹೋಗ್ತೀವಿ. ಯಾವುದೇ ಒಂದು ರಾಷ್ಟ್ರ ಏನು ನಾವು ಲಾ ಆಫ್ ದಿ ಸಿ ಅಲ್ಲಿ ಹೈಸೀಸ್ ಅಂತ ಏನಿದೆ, ಕೊನೆಯಲ್ಲಿ ಅಂದ್ರೆ ನಾರ್ತ್ ಇಂಟೆಲ್ ಶೆಲ್ಫ್ ಕೇಸ್ ಆದ ಮೇಲೆ ಈ ಈಸೆಡ್ ಎಕನಾಮಿಕ್ ಅಂದ್ರೆ ಆರ್ಥಿಕ ಅಭಿವೃದ್ಧಿಗೆ ಜಾಗವನ್ನ ಬಿಟ್ಟು ಆದ ಮೇಲೆ ಸಮುದ್ರದ ಮೇಲಿನ ನಾವಿಗೋಸ್ಕರ ಈ ಹೈಸೀಸ್ ಅನ್ನ ಜನರಲಿ ಆಗಿ ಸಾಮಾನ್ಯ ದಾರಿಯನ್ನ ಏನ್ ಮಾಡಿರ್ತಾರೆ, ಅಲ್ಲಿ ಹೋಗುವಾಗ ಯಾವುದೇ ರಾಷ್ಟ್ರ ಆಗಿರ್ಬೋದು, ಅಲ್ಲೊಂದು ಐಲ್ಯಾಂಡ್ ಇದೆ ಅಂತ ಮೊದಲ ರಾಷ್ಟ್ರ ಕಂಡುಹಿಡಿಯುತ್ತೆ. ಇವಾಗ ಒಂದ್ 10 ಜನ ಹೋಗ್ತಿರ್ತಾರೆ, ನೋಡಿರಲ್ಲ, ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಿರಲ್ಲ, ಯಾವ್ದೋ ರಾಷ್ಟ್ರ ಕಂಡುಹಿಡಿದ್ರೆ ಆ ರಾಷ್ಟ್ರ ಅಲ್ಲಿ ಫ್ಲಾಗ್ ನ ಹಾಕಿ ಇದು ನಂದು ಅಂತ ಹೇಳಿದ್ರೆ ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ಆ ರಾಷ್ಟ್ರಕ್ಕೆ ಅದೆಷ್ಟು ದೂರ ಇದ್ರೆ ಆ ರಾಷ್ಟ್ರದ ಕಂಟ್ರೋಲ್ ಅದ್ರ ಮೇಲೆ ಇರುತ್ತೆ. ಸೊ ಇದರ ಆಧಾರದ ಮೇಲೆ ಈ ಒಂದು ಆಲ್ಯಾಂಡ್ ಐಲ್ಯಾಂಡ್ ಕೇಸ್ ಅನ್ನ ತಗೊಂಡ್ರು. ಬಟ್ ಇದು ಸಕ್ಸೆಷನ್ ಅನ್ನ ನೀನ್ ತಗೊಳ್ತಿದೀವ ಅಥವಾ ಅದರ ಮೇಲೆ ನೀನ್ ಪ್ರಭುತ್ವವನ್ನ ಸಾಧಿಸ್ತಿದ್ಯಾ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ವ್ಯಾಲಿಡ್ ಗ್ರೌಂಡ್ ಇರ್ಬೇಕು. ನೀನು ಸುಮ್ನೆ ಹೋಗ್ಬಿಟ್ಟು ಇಲ್ಲ ನನಗೆ ಅದ್ ನಿಯರೆಸ್ಟ್ ಇದೆ ಅಥವಾ ನಾನೇ ಕಂಡುಹಿಡ್ದಿದ್ದು ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಯು ಕೆನಾಟ್ ಹ್ಯಾವ್ ಅದರ್ ಥಿಂಗ್ಸ್. ಅಲ್ಲಿರುವ ಪೀಪಲ್ಸ್ ಇದನ್ನ ಪಬ್ಲಿಸೈಟ್ ತಗೊಳ್ತಾರೆ, ಅಂದ್ರೆ ಅವರ ಒಂದು ಹೇಳಿಕೆಗಳನ್ನ ತಗೊಳ್ತಾರೆ. ಅದರ ಆಧಾರದ ಮೇಲೆ ದೇ ವಿಲ್ ಡಿಸೈಡ್ ವೆದರ್ ಸಚ್ ಕಂಟ್ರಿ ಹ್ಯಾವ್ ದ ಅಥಾರಿಟಿ ಟು ಕಂಟ್ರೋಲ್ ಓವರ್ ದೋಸ್ ಐಲ್ಯಾಂಡ್ಸ್ ಅಂತ. ನೆಕ್ಸ್ಟ್, ಈವನ್ ಇನ್ ದ ಬಾಂಗ್ಲಾದೇಶ್ ಡಿಫ್ಯಾಕ್ಟೋ ಇನ್ 1971 ತನಕ ಬಾಂಗ್ಲಾದೇಶಕ್ಕೂ ಅಷ್ಟೇ, ಆಫ್ಟರ್ ನಮ್ದು ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಆದ್ಮೇಲೆ ಪಾಕಿಸ್ತಾನ ಮತ್ತೆ ಅದು ಹೋದಾಗ ಅದಕ್ಕೆ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಅದಕ್ಕೆ ಡೆಫಿನೈಟ್ ಟೆರಿಟರಿ ಅಥವಾ ಅದು ತನ್ನ ಕಂಟ್ರೋಲಿಂಗ್ ಅಥಾರಿಟಿ ಇಸ್ ನಾಟ್ ದೇರ್. ಸೊ ಟಿಲ್ ದಟ್ ಡಿಫ್ಯಾಕ್ಟೋ ಇತ್ತು, ಡಿ ಜೂರೆ ಟ್ರಾನ್ಸಿಷನ್ ಅಲ್ಲಿ ಇತ್ತು. 1971 ಹೋದ್ಮೇಲೆ ದೆನ್ ಓನ್ಲಿ ದಟ್ ಕಾನೂನಾತ್ಮಕವಾದ ಮನ್ನಣೆಯನ್ನ ಅದಕ್ಕೆ ಕೊಟ್ಟರು. ಕೋಸೋವಿಯಾ ಟಿಲ್ ಟುಡೇ ದ ಪಾರ್ಷಿಯಲ್ ರೆಕಗ್ನಿಷನ್ ಇಶ್ಯೂಸ್, ಅಂದ್ರೆ ಕೆಲವೊಂದು ಅದು ಇನ್ನೂ ಕೂಡ ಫುಲ್ಫಿಲ್ ಮಾಡ್ತಿಲ್ಲ, ಬಟ್ ಅದರ ಸ್ಟೇಟ್ಹುಡ್ ಇದೆ. ಸೊ ಆ ಆಧಾರದ ಮೇಲೆ ಕೋಸೋವಿಕಕ್ಕೂ ಇದೆ. ನೆಕ್ಸ್ಟ್, ರೆಕಗ್ನಿಷನ್ ಆಫ್ ಗವರ್ನಮೆಂಟ್ ವರ್ಸಸ್ ರೆಕಗ್ನಿಷನ್ ಆಫ್ ಸ್ಟೇಟ್ ಅಂತ ತಗೊಂಡ್ರೆ GCHQ ಕೇಸ್ ಅಂತ ಒಂದಿದೆ, ದಟ್ ಈಸ್ ಕೌನ್ಸಿಲ್ ಆಫ್ ಸಿವಿಲ್ ಸರ್ವಿಸಸ್ ಯೂನಿಯನ್ಸ್ ವರ್ಸಸ್ ಮಿನಿಸ್ಟರ್ ಫಾರ್ ದಿ ಸಿವಿಲ್ ಸರ್ವಿಸಸ್ ಇನ್ UK 1983. Courts rely on executive view that regarding recognition of their foreign governments, a supporting case for separation between judiciary and executive recognition decisions. It is very important when take it to consideration by the recognition part, executive kinta government, that legislators ಇಂಪಾರ್ಟೆಂಟ್ ರೋಲು ಇರುತ್ತೆ ಮತ್ತೆ ರೂಲು ಇರುತ್ತೆ. ಆ ನಿಯಮಗಳ ಆಧಾರದ ಮೇಲೆ ಅವರು ಕೂಡ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸ್ತಿರ್ತಾರೆ. ಹಾಗಾಗಿ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಪಾರ್ಟ್ ಇಸ್ ನಾಟ್ ದೇ, ಓನ್ಲಿ ದ ಲೆಗಿಸ್ಲೇಟಿವ್ ಪಾರ್ಟ್. ವೆನ್ ದೇ ಆರ್ ಫುಲ್ಫಿಲ್ಡ್, ದೆನ್ executive can be taken an action by the recognizing the states. Okay, coming to the conclusion, that is the recognition of the state is an essential procedure so that the state can enjoy the rights and privileges as an independent community under international law. The recognition, be it de facto and de jure, both provides right, privileges and obligations. When a states get de facto recognition, its right, privileges and obligation are less, but de jure recognized by the state gets absolute rights, liabilities and privileges. The recognition of the state has some political influence of the international platform. Even the government recognition is as well. So and based on that, we say that recognition remains a vital but politically sensitive aspect under international law. While legal principles guide it, political consideration often determine its practices. But anyway, the state, the newly members wanted to come into the international community, they have to go with the aspect Montevideo Convention 1933. Based on that, what are all the rules and regulations has to be framed by the UN till today, and based on that they have to go. One more thing the student has asked regarding Kailasa. Kailasa till today it is not recognized, but it has stating that it is recognized. The website which has to be published with the public, it is not stated that the Kailasa has to be recognized, but it itself has to be made that yes, I am fulfilled my conditions of the statehood and other thing. Till today the Kailasa, because according to the UNO, the Kailasa has not coming to the picture and they will not recognizing, because it is stating that it's Hindu religion. So we are going to perform Hindu religion, and based on that they are going. So based on that, the Kailasa till today is not recognized by the United Nations. Okay. Yes. Thank you. Anybody?
Thank you, ma'am.
Thank you.
We'll take over with the Q&A session.
Yeah.
So there are few
Yes.
questions in the chat box. Vishnu Priya, please.
Yes, ma'am. So the first question here is, I have been following the discussion about, this is about Nityananda once again. In addition to Vasant sir question on Nepal, in case of Afghanistan after the Taliban's takeover in 2021, madam, your thoughts, should effective control alone be sufficient for recognizing a government, or should human rights compliance also should be a mandatory factor?
ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ದೇರ್ ಪಾ. ಯಾಕಂದ್ರೆ ಅದು ರೆಕಗ್ನೈಸ್ ಇದು ತಾಲಿಬಾನ್ದೇ ತಗೊಂಡಿದ್ದಾರೆ. ತಾಲಿಬಾನ್ ಆ ಥರ ಇರೋದ್ರಿಂದನೇ ಇನ್ನೂ ಕೂಡ ಪ್ಯಾಲೆಸ್ಟೈನ್ ಮತ್ತೆ ಅವರಿಗೆ ರೆಕಗ್ನಿಷನ್ನ ಅಂದ್ರೆ ಕೆಲವೊಂದು ಆಧಾರದ ಮೇಲೆ ರಿಸ್ಟ್ರಿಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದಾರೆ. ದೇ ಆರ್ ನಾಟ್ ರೆಕಗ್ನೈಸಿಂಗ್, ಯಾಕಂದ್ರೆ ಇದು ರೆವಲ್ಯೂಷನರಿ ಆಸ್ಪೆಕ್ಟ್ ಅಲ್ವಾ. ಸೊ ಆಸ್ ಐ ಸ್ಟೇಟೆಡ್ ಯು, ವೆನ್ ದ ರೆವಲ್ಯೂಷನರಿ ಆಸ್ಪೆಕ್ಟ್, ವೆನ್ ದ ಗವರ್ನಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಫಾಲ್ ಡೌನ್ ಅಂಡ್ ದ ಥಿಂಗ್, ದೆನ್ ದ ಸ್ಟೇಟ್ ವಿಲ್ ನಾಟ್ ರೆಕಗ್ನೈಸ್. Yes, there must be a politically organized government has to be fulfill the criteria, then they have to be approached with a new thing.
Okay. Next question is from Vasant Kumar.
Yeah.
We always discuss about a permanent membership in UN, how important it is for a state. What would be the privileges by becoming a permanent UN member? How this will help in recognition of statehood?
Yeah. ಪರ್ಮನೆಂಟ್ ಮೆಂಬರ್ಶಿಪ್ ಅಂತ ಹೇಳಿದಾಗ ನಾವೆಲ್ಲ ರೆಕಗ್ನೈಸ್ಡ್ ಅಂತ ಹೇಳಿದ್ರೆ ದೇರ್ ಮಸ್ಟ್ ಬಿ ಎ ಇಮ್ಯುನಿಟೀಸ್ ಅಂತ ಹೇಳಿದೆ. ಇಮ್ಯುನಿಟೀಸ್ ಇವಾಗ ಈವನ್ ಇಂಡಿಯಾ ದ ಪರ್ಮನೆಂಟ್ ಮೆಂಬರ್ಸ್ ಏನಿದೀವಿ ಅಥವಾ ರೆಕಗ್ನೈಸ್ ಒಂದ್ಸಲ ಡಿ ಜೂರೆ ರೆಕಗ್ನೈಸ್ಡ್ ಅಂತ ಹೇಳಿದ್ರೆ, ಸೊ ವಿ ಕ್ಯಾನ್ ಟೇಕ್ ಎ ಡೆಪ್ಟ್ because the financially we are not sound. Till today we need some of the amount, then we can take as a part of succession, because when India has to be a part of UK, we are ruled by the UK, some of our properties are there in the UK divisions also, then we can claim those properties also as a succession part, or we can give our property as a succession to the other state and take some amount like that. So very important is the state alone cannot be overlooked, or cannot come that I am satisfied and I am fulfilled all the criteria, I don't need any help. only one hand we cannot make anything, right? So we need two hands to make it clap or anything like that. Under the international law, one state, even though it has fulfilled everything and everything, it has to be there, one loophole has to be there, that will be covered up with the when we join with the communities. Okay, so that is very important. De jure or in the community level, the permanent nature has to be very much important. So whatever the thing, the international changes, because we do not have the codified laws till today in the under the international level. Based on that, the permanent nature are recognizing by the de jure, it will give some immunities and to go with the peace, to maintain the peace and tranquility in the international level. If anybody, any external aggressions has to become, automatically we can get security council support or other thing, only possible when we are permanent in nature and the recognizing by the under the UN. Okay, yes, please.
Ma'am, this is Bhagya. I'm from third year LLB.
Yes.
So you spoke about law of the seas, right? So I have a question with regard to both law of the seas and veto power.
Yes.
So as we all know about South China Sea dispute,
Yes.
where China has claimed South China to be its own, and it wants to follow its historic nine dash line concept. Even after the 2016 ruling that China shouldn't follow the nine dash line concept and follow the law of the
Yeah.
sea, China has used its veto power and has started using the
Yeah, that is
resources.
the main drawback in the veto power states.
So how right it is for other nations to actually, be at the non-benefiting end or get exploited? How can the other nations claim damages against China?
Yeah, as it is an veto power, no. So other nations, when they wanted all the four veto power, other four veto power nations has to be given against to the vote of China. Then only it can be possible that we can control over the China. Because veto power state, because financially stability has to be there by the UNO, because of these five veto power state has to be making on it, because of those things which they are giving, either it is a military, either it is a money or anything, these states are controlling and these states are helping with the other states to make peace and tranquility in the world. So based on that, even we are questioning about that, but China has to be making that stability, that no, I am going on it, because it want more and more to disturb with each other, even
Yeah, so basically veto power is exploiting the other
yes,
nations.
yes, this is the question.
And I don't
Yeah,
think, do you see a future where veto power is removed and everyone's given at least some equal
yes,
weightage?
yes, then it only possible when the all the state, even in the India, we have to be stop with taking the debt, we have to be control ourselves in the money, and we need to contribute some money to the UN. Then only every state, when they started with the contribute and they have their own thing to stability, then only it possible.
Yes, ma'am. Thank you.
Yeah, please. Anybody?
Ma'am, we have few more questions in the
Yeah,
chat box.
please.
Okay, ma'am. Despite Taiwan fulfilling all the statehood criteria of Montevideo Convention, it's unfair not to recognize it. Your thoughts on it, madam?
Taiwan even statehood has to be given, but the conditions that Taiwan's they have mentioned some of the conditions, that is politically or independently the government has to be secured, but Taiwan has to be failure. They have given more time to Taiwan to make politically organized. There is only default of the Taiwan. Based on that, it could not be recognized. But even take it example of recently in the ICC has to be mentioned, that is the terrorism part of that, that is in Afghanistan, right, in the Taliban in 2021. No country formally recognized Taliban as the government, but they themselves has to be treating that we are government, but they are disturbing entire piece of the world. But it is not recognized. Even in the Afghanistan also not recognized. Based on the change of regime in August 2021, this Taliban government will not be recognized under the international, even in the ICC also. uh, it explained that the legal consequences, that is diplomatic relations, we cannot I am fear about that. Think that now the 44 or 50 members we are there, think that we are all one state. Can we go for the diplomatic relations with the Taliban or such a type of Taliban? Can we independently go with the relations with the diplomatic? Then automatically those who are helping us, they stop. because we also supporting with the terrorist activities or some other thing based on some such criteria which we cannot explain with the juridical aspect. Based on that, they will restrict the recognitions under the community, because why we started with this community to maintain the international peace. If we are recognizing such a type of states, yes, definitely maybe it affect our peace. Based on that, they will not recognized. Okay.
Yes, ma'am.
Yeah.
Next question is from Shalu.
Mm.
Hi, ma'am. Does non-recognition affect the rights and obligation of a de facto government?
Mm. No. De facto, as I stated, no, non-recognition by the international community, it's not affect their things. They remain as a statehood. They have the authority. Think that in the world only 193 states are not there. Many states are there. More than 400 states. Till today we are not known some of the states name and other things, but they remain statehood. The state, once the statehood has to be given, and they applied for the de facto, many states they applied for the de facto recognition in the initial stage, but after the conditions which given by the UN, no, they don't want to fulfill those conditions. They themselves has to be taken it back by the applications that we do not want. We have an independent. If you want any diplomatic relations or anything in our country, you can come with that. Like that, the state remain as it is, but de facto it is left to the state to fulfill the conditions, that when they come to the de jure, the legal obligation has to be there. Some state do not want those legal obligation, that's why they will only take up. So once they're not fulfilled in the certain period of time, then automatically even in the council will take an action. Okay. As it is stated in the Kosovo state, that is Spain versus Commission. It is happened in 2023 itself, because they realized that Kosovo has to be third country for the purpose of EU recognition, that is European Union recognition in the context of country or in the state. But they said that no, Kosovo is a state for the regulatory regime, and clarified that it is did not automatically settle the question of its recognition by all states in international. ಹಾಗಾಗಿ ಅದನ್ನ ರೆಕಗ್ನೈಸ್ ಮಾಡಲಿಲ್ಲ ಕೊಸೋವನ್ನ. ಅದು ಇಲ್ಲಿಸ್ಟ್ರೇಟ್ ಏನ್ ಮಾಡಿದ್ರು, ಇಒ ಒಳಗೆ ನೀವು ಇದ್ದೀರಾ, ಬಟ್ ಯು ಕೆನಾಟ್ ಟೇಕ್ ದಟ್ ಯು ಆರ್ ಅಲೋನ್ ಆಸ್ ಎ ಸ್ಟೇಟ್ ಆಫ್ ಥಿಂಗ್ಸ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಸ್ಪೇನ್ ಒಳಗೆ ಅದು ಬಂದಿದ್ದನ್ನ ತಗೊಳ್ಳಿ. ಹಾಗಾಗಿ
Ma'am, we have few more questions. Three more questions we are having. One question is from Nivedita. Current situation wherein UN is unable to handle the human rights issue arising in a lot of countries, Israel, Pakistan issue, military coup in Myanmar, and your thoughts on this, ma'am? Ma'am, please unmute yourself.
Yeah, definitely. Your question is very good and debatable. As an international student and as an international teacher, I too have same question, because sometime it has fallen down and it is not controlling the and maintaining the peace and tranquility what we the and the protection of the human rights. Still, because the codified laws are not there, at least now the community of the state 193 is enough. They have to be go with that to make it as a codified law. Maybe once the codified laws will come under the international law, we can get all the settlement on these aspects, because in our country we have codified laws. While taking to the international law, there is no codified. Go for the succession, one of the convention is there. Go for the statehood, there is a declaration. Go for that. So only remaining states can make some of the obligations and other things. Even in the diplomatic relations, there is no codified proper laws for the purpose of treaty and other things. Okay, the common purpose, the UNO we are using. Once we can go for the codified, but it is difficult. But now onwards, because everyone know that everyone are discussing, jurists are discussing, they go for the codified and go for one. How we are going one law in one nation, that is uniform symbol, like that in international level. If we go for that, definitely United Nation will get it in touch and cancel the veto power, as your friend also stated that is everyone treated as equally and maintain equally. Maybe it could be possible.
Okay, ma'am. So next question is from Mariappa. Could you clarify whether the veto privilege is tied to states' recognition, or is it a separate political arrangement that requires a charter amendment?
Veto power is very much important. Among that, veto power state has to be recognized. Among five states, three must be recognized while going with the de jure or in the de facto. The initial stage, it may be one, two, or three. But when going to the de jure, the three veto power has to be in favor of the recognition of the state. It could be very important. Every aspect, every resolution, or everything, these five members vote is very important.
Final question, ma'am. Sometimes partial or contested recognition creates instances where some states recognize an entity while others do not, complicating international relations, right, ma'am?
ಎಸ್ ಕಾಂಪ್ಲಿಕೇಟಿಂಗ್. ಪಾರ್ಷಿಯಲಿ ರೆಕಗ್ನೈಸ್ಡ್ ಆದ ತಕ್ಷಣ ತುಂಬಾನೇ, ಯಾಕಂದ್ರೆ ಇವಾಗ ಅಕಸ್ಮಾತ್ ಕೈಲಾಸ ಅಪ್ರೋಚ್ ಆದಾಗ, ಇಫ್ ದ ಕೈಲಾಸ ಹ್ಯಾಸ್ ಟು ಬಿ ಅಪ್ರೋಚ್, when automatically based on that, some if they are influencing with the Hindu or other thing, recognize, if they got it recognized, then automatically ನಮಗೆಲ್ಲ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ಬಿಡ್ತಿತ್ತು. The Hindu region, that is Bharata as Hindu, we are disturbing with recognition of that state. So definitely so we have to move on it. ಆ ತರ ಇದ್ದಾಗ ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಪಾರ್ಷಿಯಲಿ ಮಾಡಿದ್ರು ಇದು ಮಾಡಿದ್ರು ಕೂಡ ಸೊ ಡಿಸ್ಟರ್ಬಿಂಗ್ ಆಗೇ ಆಗುತ್ತೆ. ಬಟ್ ರಿಲೇಶನ್ಶಿಪ್ ಅಂತ ಬಂದಾಗ, ಸೊ ಒನ್ ಅಂಡ್ ಅದರ್ ಥಿಂಗ್, ಎವ್ರಿ ಸ್ಟೇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಬಿಲಾಂಗಿಂಗ್ ವಿತ್ ದ ಅದರ್ ನೇಷನ್ ಅಂಡ್ ವಿ ಹ್ಯಾವ್ ಟು ಗೋ ವಿತ್ ದ ಕಮ್ಯುನಿಟಿ ಆಸ್ ವೆಲ್. ಸೊ ಆನ್ ಬೇಸ್ಡ್ ಆನ್ ದಟ್ ಫ್ರೆಂಡ್ಲಿ ರಿಲೇಷನ್ಸ್ ಇಟ್ ಇಸ್ ಮೂವ್ ಆನ್.
Okay, and another one more question, ma'am. Finally, your recommendation for students on any international law or humanitarian law certification program to enrich our knowledge?
ಎಸ್, ಇಂಟರ್ನ್ಯಾಷನಲ್ ಪ್ರೋಗ್ರಾಮ್ಸ್ ಅಂತ ಹೇಳಿದ್ರೆ ಸಿಎಂಆರ್ ಯೂನಿವರ್ಸಿಟಿಯಿಂದ 2 years ಒನ್ಸ್ ಆರ್ 3 years ಒನ್ಸ್ ಇವಾಗಲೂ ಕೂಡ ಅದಿದೆ. ಇಂಟರ್ನ್ಯಾಷನಲ್ ಮೇಲೆ ಪ್ರೊಫೆಸರ್ ಸಿಎಂಆರ್ ಬಾಲಸುಬ್ರಹ್ಮಣ್ಯನ್ ಸರ್, ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಅವರೆಲ್ಲ ನನ್ನ ಪ್ರೊಫೆಸರ್ಸ್ಗಳಿಗೆ ಅವರು ಇದ್ರಂತೆ ಆಸ್ ಎ ಮೈ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಸ್ಟೂಡೆಂಟ್ ಇನ್ LLM. ಸೊ ಆ ಥರ ಕೆಲವೊಂದು ಇಂಟರ್ನ್ಯಾಷನಲ್ ರಿಜೈಮ್ ಮೇಲೆನೆ ಕೆಲವೊಂದು 15 days ಅವರು ಕೋರ್ಸ್ ಇಡ್ತಾ ಇದ್ದಾರೆ. ಈವನ್ ವಿಡಿಯೋಸ್ಗಳು ಯೂಟ್ಯೂಬಲ್ಲಿ ಇದೆ, ಯು ಕ್ಯಾನ್ ಗೋ ಅಂಡ್ ಚೆಕ್. ಸಿಎಂಆರ್ ಯೂನಿವರ್ಸಿಟಿ ಅಂತ ಹೋದ್ರೆ ತುಂಬಾ ಚೆನ್ನಾಗಿ, ಅಂದ್ರೆ ಇನಿಷಿಯಲ್ ಸ್ಟೇಜ್ ಪಾರ್ಟ್ ಆಫ್ ಏನು ಇಂಟರ್ನ್ಯಾಷನಲ್ ಯಾಕೆ ಬಂತು ಏನು ಅಂತ ಪ್ರೊಫೆಸರ್ ಸುಬ್ರಹ್ಮಣ್ಯ ಹ್ಯಾಸ್ ಗಿವನ್ 14 lectures series. You check it out, it is very good. Like that, some books which are available ನಾವು ಬರೀ ಎಕ್ಸಾಮ್ ಪಾಯಿಂಟ್ ಆಫ್ ವ್ಯೂ ಇಂಡಿಯನ್ ಆಥರ್ಸ್ಗಳಿಗೆ ಹೋಗ್ತೀವಿ, ಕಪೂರು ಆ ಥರ ಎಲ್ಲ. ಬಟ್ ಗೋ ವಿತ್ ಸಮ್ ಆಥರ್ಸ್ who are in the good explanation given by the things in ಯಾರು ಇಂಟರ್ನ್ಯಾಷನಲ್ ಇದರಲ್ಲಿ ಹೋಗಿ. ಮತ್ತೆ ಕೇಸ್ ಸ್ಟಡೀಸ್ ಅಂತಾನೆ ಒಂದು ಬುಕ್ ಬರುತ್ತೆ, ಕೇಸ್ ಸ್ಟಡೀಸ್ ಅಂತ. ಫಸ್ಟ್ ಯು ಚೆಕ್ ವಿತ್ ದ ಕೇಸ್ ಸ್ಟಡೀಸ್ ಬುಕ್, then you realize how the international law was developed, what exactly need for the improvement of international law, and automatically I think we go for the further action ಅಂತ.
Okay, ma'am.
Yes, any other thing? Yeah, thank you students for your gracious presence even in the evening, and thank you the hosting college and Vishnu Priya and others. Thank you Lalita ma'am giving an opportunity.
Vishnu Priya, you can move for the vote of thanks.
Yes, ma'am. Thank you so much, ma'am, for your truly insightful and thought-provoking section. I want to especially thank you for explaining us this everything in a dual language so that everyone can understand with more clarity. So actually, your lecture has enriched our understanding on the theories of recognition, types, doctrines, and everything. So special thanks to you, ma'am, for joining us this time and to share your valuable knowledge and experiences with us, ma'am. And I also extend my sincere thanks to our respected management, our beloved principal Lalita ma'am, faculty members, especially Ramya ma'am and Hema ma'am, who was present throughout the session, and back in support team for their constant support and efforts in making this event possible. So thanks for everyone, on all the participants who is joining us today and making the session meaningful and wonderful. So have a wonderful evening.
Thank you ma'am. Thank you.
Thank you, ma'am.
Shilpa
ma'am, thank you, ma'am. Once I had approached you, accepted for the seminar, and you have given a wonderful lecturer. And in regional languages, some of the Kannada medium students, that doesn't know like how we want to be cope up with the English everything. For them, it is very useful seminar. What you have given the webinar over here. and thank you very much for your precious presentation, ma'am. Thank you.
Thank you, ma'am. Thank you, all the Ramya ma'am and Emma ma'am, Vishnu Priya,
Thank you, ma'am.
and all the students.
Thanks
Thank
for
you.
Thank you,
your
ma'am.
Yeah.
Thank you, madam.
Thank you.
Thank you.
Thanks
Thank you,
for
ma'am.
You
your
have
time.
covered you have covered all the areas at state recognition of state types, theories in detail, which is like to be explained in detail. You have summarized for the students so excellently, and as Lalita ma'am said, like both the languages you have handled it so beautifully. A very thank you from our side.
Yes,
Hoping to
ma'am.
meet more sessions from you.
Thank you so much, ma'am.
Definitely, ma'am. Thank you, students. Thank you, ma'am. Can I leave?
Yes, ma'am.
Thank you.
Yes, ma'am. Thank you so much.
Thank you.
Thank you.
Good day.
Have a
Good night.
good evening.